Yes.
My lord, may it please lordship. Item number 16 and 17, my lord.
Yes.
My lord, we are making a joint prayer, my lord. In this matter, my lord, we will be given 4 weeks more time, my lord, to settle the dispute which was there.
Is it being settled or?
Settled, my lord, only my lord, some approval is required, that will not come.
Okay. Mr.
AB Day, my lord, for IIT Guwahati.
AB Day for
IIT Guwahati.
IIT Guwahati and Mr. G.S. Sahawala for the respondent.
Yes.
Number one, submit that the out of court settlement is at the fag end and there's a probability that it will be settled. This is the matter
After 4 weeks.
after 4 weeks.
Keep your plan.
Happy, Lordship. I'd like to mention for listing of an interlocutory application, Lordship, the main case is listed tomorrow, Lordship. That interlocutory application may be listed tomorrow along with that notice of like.
Wait, please, your lordships. I'd like to mention item 12 of today's list.
Yeah.
Lordships, pursuant to the order dated 17/3 of this honorable court, an affidavit was filed on the 5th, that is Friday. There's a word missing at page 63 of that affidavit, madam. If I may please be permitted to add that.
No. You'll have to put in a extra page. You'll have to replace that page.
I will do that, lordship.
That by hand is cannot be allowed.
May I be permitted to replace the
Okay.
page?
You have affidavit filed by?
The Deputy Commissioner of Hailakandi, madam.
Okay. Right. Item,
Item 12, your lordships.
okay. A request has been made to replace page number
63, lordships,
63.
by adding the word not.
In as much as the affidavit, the said affidavit filed by the Deputy Commissioner Hailakandi has been filed without the word inverted commas NOT. But the learned counsel for the Deputy Commissioner submits that he would like to replace the said page with another page by
The-
adding the word NOT, huh? Where the counsel is allowed. The page number so which will be replaced within
In the course of the day, my lord.
within the course of it.
Deeply obliged.
And what about what about the other side? Are we hearing this matter or what?
Yes, my lord. Let it come up, my lord. I'll do it in the course of the day. Deeply obliged.
Please, please,
Part of the order. We'll say it will be part of the order.
please, Your Lordship. I'd like to mention item number 20, Your Lordship.
Yes,
Your Lordship, due to my ill health, Your Lordship, I couldn't prepare my case properly, Your Lordship. Your Lordship, may kindly, with the concern of the other side, Your Lordship, kindly fix the matter next week, Your Lordship.
no. Madam, there's no case out here. You file a section 18 application.
Your Lordship, kindly,
Affidavit Act. Madam, there's an alternative remedy
Your
available.
Lordship, but the
There is no
case is,
case. There is no case, madam.
the case is, Your
The
Lordship.
court has given enough directions to the High
Yes, Your
Court.
Lordship.
We are bound by the direction.
Yes, Your Lordship, but the case is not on that, Your Lordship.
The
The
case,
case is that
the case is on the
upgrade,
question of your NPA status being
upgrade,
upgraded to standard assets, correct?
Your Lordship, the matter related to surfacing, but the
Huh?
thing is that, Your Lordship, my case is that
For that, you are now you have come against an order of the tribunal.
no, Lordship.
Then
No, Lordship, for the sake of my argument, Your Lordship, I have annexed that page, Your
we'll take
Lordship.
it up, madam. No adjournment. No adjournment, sorry. Yes, next.
May I please, Your Lordship, I'd like to mention for listing for criminal appeal, Lordship. It was earlier listed on in the month of January, Lordship,
Yes,
for orders, Lordship.
when?
Lordship, any date this week, Lordship?
This week, not this week, next week.
Next week, Monday, Lordship. Deeply obliged.
Wait, please, Your Lordship. Your Lordship, with the consent of the other side, I'd beg to mention item number 5. Your Lordship,
Yes.
I'm seeking 2 weeks' time to file affidavit.
Yeah, for whom?
Your Lordship, I'm for the appellant.
Affidavit against what?
Your Lordship, on the last day, we have apprised the Honorable Court that we have filed an additional affidavit and submitted that some more additional submission will be put forward in the affidavit. Your Lordship, the Honorable Court allowed a prayer. Your Lordship, so I'm seeking 2 weeks time to file affidavit.
You have not
additional.
filed it.
We have filed, but some more additional submission was.
The additional submissions required. The long and short of your case is basically non-payment of rent and electricity. Then
Some more.
the issue is whether the standard, whether there's a question of standard rent needed to be made or not, that's all.
Yes, Your Lordship.
Then, what additional information are required to put in?
Lordship,
So, madam, don't ask for things which are not relevant. If you're going to add something relevant to the case, it's okay. But if you're not going to add anything relevant, you're wasting my time, you're wasting your own time.
Lordship, some relevant points have to be added.
What are those relevant points? Tell me.
Lordship, the arguing counsel, who is the senior counsel.
Tell the arguing counsel to come. What are the relevant points? The only issues with regard to the rent that has been computed by the committee or the authority has not been accepted. That's all. There's nothing beyond that. Let him come. We'll see. We'll wait for you today.
Much obliged.
May I please, Your Honor?
Yes.
Lordship, I am praying for listing of a matrimonial appeal which was last listed on 20th March of 2024.
Next week.
May it please, my lords. My lord, this is a contempt petition, my lord. The relevant portions of the order is at page 23, starts at para 36. If I may read it, my lord. Page 36, my lord. Page 23, my lord, para
Sir, they're supposed to file affidavit in this two writ petition.
my lord.
And that is a condition precedent.
No, condition precedent, my lord.
Condition precedent for the stay order being vacated.
My lord.
Now that has not been done.
That within, they have to file it within 2 weeks.
Has
No,
it been done?
No, that has not been done.
Has it been filed now?
No, later on the 4th or 5th, I think they have filed it.
Then they have filed it.
Well, but
But then they have again settled the
my lord may kindly come to para 37 at page 24. Accordingly, the impugn order dated 26/2025 has been conditionally interfered with. Thus, it is made clear that unless and until an affidavit as directed herein before is filed, the order dated 26/2025 passed by the learned single judge in I and so shall continue to hold the field. The stay-wide interim order dated 12/2/2025 passed in WPC number 78 shall stand vacated as and when the affidavit as directed above is filed by the competent authority or the
Okay,
appellate.
right. Heard Mr. S. Sharma, then senior counsel for the petitioner, assisted by Ms. P. Foucault. The learned senior counsel submits that the order dated 17/7/2025 passed in WA 152 of 2025 has not been complied with. And the respondent has allotted the work order to a third party pursuant to the NIT dated
My lord, this is the
NIT dated
2025/B/589545438. This is annexure 2, my lord, on the top.
there's no number. All,
B detail, this is GM number. The annexure 2, page 25.
okay.
Page 25, last page, annexure 2.
NIT dated.
Page
NIT
13
number
is there.
says so.
Page 13 is there.
Page 13.
Page 13. Page 13.
Same number at para 8. my lord.
NIT dated 1/2/2025. So where is the contempt?
My lord, at annexure 2, my lord, may kindly see the contract date. They've opened the bids on 2nd of August.
No, you see, that portion with regards to the time. They had not submitted
That is the most vital part.
No, but then subsequent to that, this has been done. And now the only thing that remains is that the award of the tender will be subject to the outcome of those two writ petitions.
Those two writ petitions, my lord.
Hearing on those two writ petitions.
My lord, may kindly hear me. At 37, I have read, my lord. 38, my lord, at page 24. At
Yes.
page 24, 38. Moreover, it is further made clear that if the affidavit is not filed within the time as allowed herein before, failing which this order shall stand lapsed and revoked by a flux of time without requiring any further order of the court.
Okay. Whatever. Though the respondents in WPC 6142/2024 and WPC 738/2024. 2025. 738/2025 had not filed their affidavits within the 2-week time limit provided by this court. As such, the conditional vacation of the interim stay order dated 12/2/2025 passed in WPC number 738/2025 no longer subsisted. And for which the contract could not have been awarded pursuant to the NIT dated transfer. Next paragraph. The applicants, no, the petitioners also submits that the affidavits have been filed by the respondents in the two writ petitions on
4th of 5th, because we have not been served copies, my lord, because we
on 4th of 5th,
4th or 5th of August. We have not been served copies.
on 4th or 5th of August 2025.
And the date expires on the 30th of
Though the
July.
date for submission of the same had expired.
30. 37.
31. 31/7. 31/7/2025. He also submits that the petitioners have not been given a copy of the affidavit filed by the state respondent in the two writ petitions. Till the issue notice returnable in 4 weeks. Petitioner takes steps for serves on notice upon the respondent for a registered proceeding within
3 days.
3 days. List the matter on give a date. Or can it be this month? Well, then, it's returnable in 3 weeks, huh?
My lord. Obliged.
This contempt petition is, my lord, for lordship's orders violation. Page 40 is order dated 3/9/24. And if the lordships kindly see the operative part, page 51, para 30, my lord, small paragraph. After lordship has passed this order, they challenged this order in Supreme Court. That was dismissed. They filed review petition. That was also dismissed, my lord. Still, they're continuing non-complying with the order.
So you want your pay
Yes, my lord.
with interest.
Yes. Area pay, my lord. Area.
Third, Mr. M. Not Bennett counsel for the senior counsel for the petitioners
Yes.
assisted by Mr. D. P. Bora. Who submits that the order dated 3/9/24, passed in WPC numbers, no, WA.
WM, no, my lord,
W-
against CAT order,
WPC.
yes.
WPC
Tribunal order.
767 of 2024. Requiring payment of arrear back wages has not been done till date. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondent by a registered post with AD within 3 days. List the matter on given date.
Obliged, my lord.
May I please your lordship, my lord? This PIL Sumoto is lordship pertinent to basic amenities in the major religious places, lordship. On the last occasion, lordship, this honorable court,
Supposed to be made.
yes, lord.
Correct.
Yes, lordship. We need
So what is this? Who's the,
we are supposed to file a compilation, lordship, against the affidavit filed at this.
so where is that?
Lordship may kindly grant us further 2 weeks time, lordship. Most of the
Mr.
affidavits are voluminous, lord.
Mr.
And case normal, lordship.
N.K. Sharma, learned counsel for the petitioner. Is for how much time?
2 weeks, lord.
2 weeks time. To prepare a comparative chart with suggestions in terms of the earlier order dated 6/8/24. This is a matter after 2 weeks.
Deeply, lord.
Therefore, yes, madam, what is the status?
Some more time may be granted to get.
What is the status?
That instruction we have not received, not yet. Two weeks time will be
No, no,
granted.
we're listing it next week. You've taken enough time. Miss
MDB lodged.
M. Devi, learned
Government advocate.
government advocate. 6, some more time to obtain instructions
Not yet.
regard to the stage of construction of the bridge over Tip Kai River, TIP-KAI River. In terms of the earlier order dated 4/8/25. This is a matter on next week. Give it.
Lordship, the pending disposal of the case might not be bar on the respondent to continue the construction, my lordship.
You want them to complete, where's the bar?
Obliged not.
Your Lordship, I'm being led by Senior Counsel Dr. Ashok Saraf in this matter, Your Lordship. Kindly 1 week's accommodation may be granted, Your Lordship.
I have no objection. In fact, Karbi Anglong is the main concerned opposite party, Lord. State has very limited role in this case.
The only thing is with regard to the rent that is to be paid.
Exactly.
Now, who is to make the standard rent? And what is the urban areas rent control act being followed here?
Assam Urban Areas Rent Control Act 1972, there is a provision for that from 5 minor.
So the urban areas rent, so does this property of the petitioner come within that urban areas? Come within the urban area, then the district collector.
No, my lord,
Other?
civil code is the, my lord, absolutely, civil code. If it is,
Decide.
my lord, the government has already determined the, my lord.
So under the urban areas rent control act, there
Yes.
must be an authority
Yes,
who is to decide the
Yes, my lord,
rent.
that is the, if he is dissatisfied with the standard and calculates, my lord, if any dispute in respect of the rent, it should go to the civil court.
That
Under
is,
1972 Act.
so,
In this particular case, my lord.
so the competent authority has taken a decision,
Civil court.
correct, has taken a
Correct,
decision.
correct, correct.
There's nothing, okay,
And there is a dispute regarding the ownership also of the property.
that's a different
Yeah,
issue.
yes. So ultimately, they have to go to the civil court.
Correct. Because when the competent authority has taken a decision, whether that is a correct rent or not, whether this high court can decide.
Lordship, 1 week's accommodation may be granted.
For what? What do you?
Your Lordship, the Senior Counsel, Dr. Ashok Saraf is going to be putting submissions.
Today also you could have done the same. That's why it is listed. Okay, right. Next week, we'll fix it next.
Next Wednesday, Lordship.
Okay, right. Miss
Ms. B. Poddar.
B. Poddar, praise for adjournment on the ground that the Dr. A. Sharaf, A.K. Sharaf, counsel for the
Appellant.
appellant, is what?
Lordship is seeking.
Is on his legs in another court or what?
Your Lordship,
Is
wanted to file an affidavit, Your Lordship.
no, what affidavit? This is a question of law. There's nothing affidavit. Don't change your stand, madam. The day goes longer. On the ground that what on the ground that he's having some personal difficulty today. Mr. D. Saike, Leonard A.G. Assam, and Mr. J. Chotia, Leonard counsel for the KAC are present. Mr. Bhattacharjee for the Chakrabarti for the is also on the parties list the matter on Wednesday.
Deeply obliged.
May I please, Your Lordship? Lordship, this appeal has been filed challenging the conviction
Hmm.
under section 103, 140 of the BNS section.
Third, Mr.
You Chaudhary.
U. Chaudhary, Leonard counsel for the appellant, who submits that the judgment dated
26/6.
2025 plus by the section Judge Udalguri Assam in sections bracket T-1, right, was case number 12 of 2025 under section 1, by which the appellant has been convicted under section 103 BNSS, read with section 140 bracket 1 BNS should be set aside. Admit the appeal. All for the PCR. Ms. A. Begum, additional PP appears for the state. This is the matter of the court.
There is an I.
The I, right? Ms. A. Begum is granted 5 weeks time
Five.
to file written objections to the application made under section 430 BNSS. This is the matter of the 5 weeks. The earlier one also make it 5 weeks.
Obliged, Your Lordship.
Yes. So you want this matter disposed of in line with that earlier judgment or what?
Lordship, there is a direction to the honorable court to take instruction as to whether the similarly any decision has been taken by the government to the similarly situated person for consideration of their encadrement in the post of Hidayat Your Lordship, because all those persons who are in supernumerary post, Your Lordship, and direction
No,
was
at the
issued-
end of the day, you want this matter to be disposed of in line with the decision made in the earlier writ appeal 228, correct? That's
Lordship.
Bishnoi and this is, no,
So there is a direction was issued to file an affidavit as to whether any the state government has any taken any decision.
no, there's nothing to file in the affidavit.
Lordship, in earlier order,
Correct.
earlier order is there, Lordship.
There are.
$25.7.
No, you see, at the end of the matter, the issue is with regard to that judgment of the division bench
Lordship.
in Dilip Talukdar's case, correct?
No.
Now you are in the same boat.
Lordship, but in the there is an order of this honorable court in table 5 of 24. And Lordship, Niban Chandra Das and 27 others. There is a copy of this.
Huh?
There is a copy of this order, Your Lordship.
5 of 24.
Lordship. There's a
So we dispose of this in light of this order only. When you go there, they almost 100% they have not taken a decision as on this.
Lordship, let them to place the instruction first, Your Lordship.
Why?
And
How will that help? This is a covered matter. Otherwise, we'll dispose this on merit. This is the best order you can get. I don't think you can get a better order than this. Whether this order has been complied with, that's a different thing.
Absolutely.
This disposal, the case of pending consideration. So have you made any application
That
to
was
the
applicable.
government?
Lordship,
Just a minute. The order passed here says that the state government shall take a decision for encadrement of the airport. If the encadrement for the post is pending consideration with the state government. Question is, have you made any application to the government for encadrement of your post?
so that instruction I have to take lordship,
Then-
fix it matter.
So with
this
this
lordship,
we will say that if you have not taken a decision for encadrement, you take a decision for encadrment. You take an, if you have not taken a, if you have not submitted an application for encadrment, you submit an application for encadrment. That's all. You cannot, you see, those things are different. You put this order, no? Already, this is different disposal of to the other way. Is pending consideration with the state government. Then it helps to the picture on the matter without the equivalent. So this matter is the,
you have taken.
because the Dilip Kumar judgment, now we are bound by that. Once we are bound by the Dilip Kumar judgment, we have to pass an order in terms of that judgment. Now, if you want to, you want this court to follow Dilip Kumar judgment or this judgment? That's the question. You take the choice now.
Also, for time being a lawsuit or fix it or any
No,
other day.
no, fixing. You see, there's no point adjourning the matter on such ground. Yeah, we are going to take a decision either this way or that way. You want to follow Dilip Kumar judgment or you want us to follow the subsequent? order?
Lordship, 2 p.m.
Listen, Lordship. Lordship, here the petitioner father, he is an army officer in the rank of a colonel. So he does not come under the category of central government employee. Despite of we submitting to the court that he does not have a civil post, the learned single judge has come to a finding that the petitioner father is a central government employee and directed us to
Your client is in the army.
Correct.
Should be formally dressed up.
I'm sorry, my lord.
Should be formally dressed up.
He should be, my lord, but he has taken a leave from duty, my lord, to attend the court proceeding.
Normal coat, shirt.
Absolutely correct, my lord.
Then-
I completely agree.
This is not a, this is a court.
Completely
Yes,
agree.
then
We'll keep this in mind, my lord. This is a mistake. We'll keep it in mind, definitely.
So Lordship may turn to page 50 of the impugned judgment and order.
yes, page 50.
Yes, paragraph 50.
Yes.
The petitioner, who is the daughter of Colonel Lovelace Pangal, who is posted as the commanding officer of 1st Nagaland Battalion NCC Kohima, is eligible under category 4 of the office memorandum dated 28 July 2025, prescribing the
I think it should be dress code.
But if it all with your permission, Lord, may I send him out in case that is a.
Do that.
Will we do that, please? I'm so grateful.
Because the way,
I
officer, colonel, to come, baggy pants, tight pocket,
but I
the
completely,
headland also.
completely agree.
being the counsel, you should have instructed him.
But the only problem was,
Officer of the court.
I agree, my lord, the only problem was, my lord, because of this issue, my lord, his daughter's admission to a medical college is on hold. And he's been worried about that. We were also briefed at the last minute, my lord. Otherwise, we would have made sure that this should not have happened in the court. So I take responsibility, my lord, and I apologize. I just request that my lord will take a lenient view on this. That's all.
Lordship, may I continue?
Slightly, that's fine. Anyway, carry on.
Yes. Page 50, para 50, your lordship.
Yes.
The petitioner, who is the daughter of Colonel Novelish Pangal, who is posted as the commanding officer of 1st Nagaland Battalion NCC Kohima, is eligible under category 4 of the office memorandum dated 28 July 2025, prescribing the guidelines for allocation of central pool MBBS BDS seat for the academic year 2025-2026. She being the ward of a central government employee. The learned single judge has came to a finding that she is the ward of the central government employee posted in and having his headquarters in the state of Nagaland is eligible as per the office memorandum dated 28 July 2025 to be considered for selection and nomination against central pool MBBS seat allocated by the central government to the state of Nagaland for the academic year 2025-26. Her father, who is an officer of Indian Army posted in the state of Nagaland, cannot be treated as a mere bird of passage without any root and without any connection to the state of Nagaland, who just come to the state of Nagaland so that his daughter may avail the benefit of an MBBS seat against central pool. He has been transferred and posted to the state of Nagaland for a period of 2 years to serve the state, and thus his daughter became eligible under category 4 of the office memorandum dated 28 July 2025 issued by the central government. 51. In view of the discussion made in the foregoing paragraph and reasons stated therein, the impugn notification number such and such dated 9/9/2021 issued by the Government of Nagaland Higher and Technical Education Department is found to be arbitrary and violative of fundamental rights of the petitioner guaranteed to her under Article 14 of the Constitution of India as regards its application for selection and nomination of candidates against central pool MBBS BDS seat for the academic year 2025-26. Accordingly, the impugn notification is set aside and quashed with regard to its application for selection and nomination of candidates against central pool MBBS BDS seat for the academic year 25-26. Lordship, here the BDS is not the subject matter before the learned single judge, but even the learned single judge has quashed and set aside the central pool of BDS seat also, Lordship. Regard to the selection and nomination of
This
candidates,
is not an issue.
BDS is not the subject matter before the learned single judge. We are only concerned with MBBS central pool, but the learned single judge has even touched the BDS central pool seat, Lordship. Then Lordship may come to page 52, para 56.
Page?
Page 52, para 56.
Yes.
Yes, as it was informed to this court by the learned additional advocate general Nagaland during the course of the hearing that only one seat has been kept vacant in pursuant to this court order dated 28/7/2025, and other 41 seats have already been allocated to other eligible candidates on the basis of merit, and they have been directed to proceed to take admission in the respective allocated medical colleges. Hence, the respondent number 3 is hereby directed to allocate the available vacant MBBS seat under central pool for the state of Nagaland to the petitioner. Since the last date of admission has been notified to be 18, was incorrect, Lordship. At that point of time, there was no notification. The last date was not notified. Notified to be 18th of August 2025, the respondent number 3 shall do the needful in this regard within 2 days from the date of this order, so as to enable the petitioner to take admission in the medical college allocated to her within the time prescribed. So learned single judge has directed the state to give allocation to the petitioner within 2 days, seeing that the petitioner is the ward of a central government employee, Lordship. Lordship may kindly turn to page 41 of the judgment. The learned advocate general submission was totally ignored. Page 41, para 28. The learned advocate General Nagaland has also submitted that the father of the petitioner cannot be regarded as an officer of All India Service born on Nagaland cadre, as he does not belong to either Indian Administrative Service, Indian Police Service, or other services recognized as All India Services to avail the benefit of an MBBS seat against Central Pool. He submits that apart from 42 seats allocated under the Central Pool for the state of Nagaland, the Ministry of Defense, to which the father of the petitioner belongs to, has also been allocated 42 seats under the central pool, and the petitioner could have competed and availed the benefit under the said quota. So, Your Lordship, here, 42 central pool seat was allocated to the state of Nagaland because we are deficient in medical education. And even 42 central pool seat has been allocated to the defense ministry, to the Ministry of Defense. The petitioner father belonged to the Ministry of Defense, so she could have competed in that one.
There is one question. Can the state government officials or the central government officials,
Yes,
can they wards participate in for allocation of the Ministry of Defense seats?
no, because it is only for the defense personnel only, Lordship. Because the meaning of what is a central government employee has been defined under the CCS rules, Your Lordship. And the army, they are subject to the Army Act, Lordship. If they are considered as a central government employee, then there would not be a provision for them, for the Ministry of Defense, Your Lordship. But despite of we submitted before the learned single judge that even the petitioner has got a 42 central pool seat, Lordship, the learned single judge has totally ignored all the facts which was supported by the
Ministry of Defense seats are all India, or is it based all India or only for Nagaland?
It is on the basis of merit. So the petitioner
It will be all India.
India. So the petitioner, she scored a mark of 455, Lordship, out of 720. And her All India rank is 1,13,803. So her rank does not make her eligible to compete in the All India rank in her state of Haryana, from where she belongs, and even in the Ministry of Defense. That's why the petitioner is claiming the Nagaland Central Pool seat, saying that her father belongs to the central government employee, Lordship. Lordship, I may be allowed to take you to page 54 to show as to how. Lordship, this page 54, this is the statewide medical colleges in India as on February 54. Annexure 2, page 54. Has your Lordship got it?
Yes.
Yes, as on February 2025, your Lordship, Haryana. Haryana has 13 medical colleges. As compared to Nagaland, we have only one medical college where we started in the year 2023, Lordship.
Yes.
Yes. Then the next page, page 56, Lordship. This is the central seat distribution or central pool quota. 56. This is Ministry of Defense, your Lordship. That is 42 for wards of defense personnel. Then come down to Nagaland, we have 42.
Yeah.
So this is the seat distribution or central pool. Then Lordship may turn to page 57. This is the guidelines given by the Ministry of Health and Family Welfare. This is the letter dated 31 July 2025. This is to the Secretary, Medical Health and Family Welfare, Government of Nagaland. There are 9 beneficiary states, UT as well as state lordship.
This for what?
This is for the central pool seat for the beneficiary state lordship. So Nagaland is deficient in medical education. That's why we got the
What does it say? What does this letter say?
the letter says that, sir, I am directed to forward herewith a statement indicating the number of MBBS BDS seats along with the colleges concerned allotted to your state union territories for the academic session 2025-26 from the central pool. The following points may kindly be kept in view in this regard. It is informed that only the children of 1 permanent resident of the state UT concerned, 2 the employees of the state UT concerned, 3 the employees of the central other state UT concerned on deputation to the state UT concerned, and number 4 the employees of the central other state UT government posted in and having their headquarters within the state UT concerned will be eligible, lordship. So it talks about the permanent resident of the state or the UT, or the employees of the state or the UT, or the employees of the central or state UT who are on deputation to the concerned state, or a central government employee who have been posted to that place, lordship. Here, the petitioner father, he has been claiming that from 27th.
He is saying that he is an employee of the central government.
Yes, he is saying that he is an employee. It cannot be. That is a total erroneous interpretation, lordship.
So employee of the, he's an employee of the central government, but would it be employee of the?
Because he's not holding a
Civil
civil post.
So it's, according to you,
Yes,
this employee of the central government would only pertain to those holding a civil post.
yes, lordship.
Is there-
Yes, yes.
Hmm.
So, lordship, page 59 is the different colleges from the central pool to the state of Nagaland.
Page 59.
Yes, page 59 is the statement indicating the allocation of MBBS BDSC from the central pool quota to the state of Nagaland for the academic session 2025-2026, lordship. So we have got 30 colleges, lordship, for the MBBS seat. The total number comes to 42 seats.
Yes.
Yes. Then thereafter, lordship, page 61. This is the 16 August 2024. This seat allocation was done to the Ministry of Defense.
For 42 seats.
Yes, for 42 seats. The undersigned is directed to forward herewith a statement indicating the number of BDS stake along with the medical dental colleges concerned allocated for the academic session such as such from the central pool for the Ministry of Home Affairs, Cabinet Secretariat, Ministry of Defense, and Ministry of External Affairs. Then lordship, page 63 is the
Please read the memorandum. Just line past all this.
lordship.
What are the contents?
The contents, because here the undersigned is directed to forward herewith a statement indicating the number of MBBS BDS seats along with the medical dental colleges concerned allocated for the academic session 2024-25 from the central pool for the Ministry of Home Affairs, Cabinet
Now
Secretary.
let us see.
Yes.
Now, okay, basically your case is that the it will only apply. This seats will only be applicable to the central, state, or UT government
Yes,
personnel who are holding civil posts,
yes,
and
lordship.
not to the defense personnel.
Yes, yes,
Basically.
basic, yes, lordship.
Now, what are you relying upon to buttress your argument?
Okay, rely on that. Lordship, then basing on that one, lordship may come to CCS Central Civil Service Classification Control and Appeal Rules 1965.
Yes.
Lordship may come to definition H, rule 2H.
Yes.
Rule 2H define government servant. Government servant means a person, one, is a member of a service or holds a civil post under the union and includes any such person on foreign service or whose services are temporarily placed at the disposal of a state government or a local or other authority. Number two, is a member of a service or holds a civil post under a state government and whose services are temporarily placed at the disposal of the central government. Number three, is in the service of a local or other authority and whose services are temporarily placed at the disposal of the central government. Then, Your Lordship.
No, just a minute. Government servant means a person who is a member of a service.
Yes, member of a service.
Member of what service?
So, what is the meaning of service is mentioned at M. M. Rule 2M. Service means a civil service of the union. Service means a civil service of the union, Lordship. So the petitioner, he is not holding a civil post. He is holding the military, Your Lordship.
Would this service include defense service?
No, Lordship, the defense service is only on the civilian side of the defense. Only on the civilian, Lordship. That is at E. Defense services means services under the government of India in the Ministry of Defense paid out of the defense service estimate and not subject to the army.
Not
So-
except to the army.
Yes. So the petitioner father, he is an officer in the rank of colonel. He is subject to Army Act, Your Lordship. But here it talks about the civilian service. Those who are looking after the administration, the logistic and maintenance and all. So they do not come under the army, they comes under the Central Civil Service, Lordship. So, Lordship, despite of
No, okay.
yes.
Why did the single bench say that that the award of the
Central government employee,
yes.
Lordship.
Okay, well, with this writ petitioner, why should she be given a seat? What is the basis?
Lordship here, Lordship may turn to page 46. Para 40. Page 46, para 40. The petitioner was initially heavily reliant on the office communication dated 9/12/1986. But Your Lordship, for each academic station, the Ministry of Health and Family Welfare issued guidelines for each academic session. So the communication of 9/12/1986 becomes irrelevant, Your Lordship.
Okay.
Here, para 40, though the Learned Senior Counsel for the petitioner has mainly relied on the guidelines issued by the Ministry of Health and Family Welfare, Government of India to all the state UTs, without medical college by its letter bearing number such and such dated 9/12/1986. However, the Government of India Ministry of Health and Family Welfare has issued the office memorandum dated 28 July 2025 prescribing the guidelines for allocation of central pool MBBS BDSC for the academic year 25-26. A copy of the said guideline has been marked to the Secretary Health and Family Welfare Department, Nagaland also. 41. On perusal of the copy of aforesaid office memorandum submitted as Annexure B to the affidavit in opposition filed by the present petitioner in the interlocutory application number such and such, in connection with WPC number such and such, it appears that at clause 1(2) of the SIG guidelines, eligibility criteria of the candidates for selection and nomination against the central pool of MBBS seat for the academic year 25-26 has been provided. 42. Clause 1.2 of the aforesaid office memorandum provides as follows. 1.2 eligibility condition. Only the children of permanent residents of the state UT concerned, the employees of the state UT government concerned, the employees of the central other state UT government on deputation to the state UT concerned, and 4, the employees of the central other state UT government posted in and having their headquarters within the state UT concerned will be eligible. The children of central state UT government employees aforementioned should be treated at par with the local resident. 43. From above guidelines.
No, so this
Yes.
is this clause 1, this office memorandum is of,
Is of 28 July 2025, Lordship. This is the guideline given by the Ministry of Health Affairs for the central pool MBBS seat.
okay, so out here, so the learned single judge has applied this. Well,
Yes, here, Lordship, it comes at page 50, para 50, Lordship.
uh,
The petitioner, para 50, the petitioner who is the daughter of Colonel Lovelace Pangal, who is posted as the commanding officer of,
eligible under.
yes, because she being the ward of a central government employee. The learned single judge has come to the finding that she is the ward of the central government employee, Lordship. And we have our notification, the policy, that is at page 76, Lordship. The petitioner, she challenged our policy, Lordship, which disqualifies her to get the central pool MBBS seat, Lordship, because she passed out her class 12 from Delhi. She never studied in Nagaland for class 10 and class 12, nor her father, Your Lordship, if at all, if her father comes under the central government employee also. Her father has not been posted in Nagaland for the last 3 years, Lordship. So she make a challenge of this our government policy, which disqualifies her, and the learned single judge has quashed and set aside this notification in respect of the MBBS and BDS. For the MBBS and BDS also, we have already selected and nominated the candidate, and they had already undergone, taken the admission, Lordship.
They're still working, they're still
They have taken
undergoing
some-
classes.
some.
No, my lord, the classes are starting from 22nd September, and as per the directions of this.
How would she know? Because the learned single judge has directed us to reserve one seat. How would she know
I am saying
the
classes are starting on
college
22nd.
where we have
September.
reserved
The
for her?
curriculum does not start till 22nd September. And by the honorable court's order, my lord, one seat has been kept vacant. That is the direction, my lord, in the last order of this honorable court and also of the learned single judge, my lord. So that is there.
So, Lordship, we have already, those candidates, we have already given the nomination. They had already taken the admission. So now the totally perversity of the learned single judge is he has even the Lordship interfere into the BDS, which is not the subject matter before this learned court. And even the learned single judge has also directed the state, Lordship, may kindly see, to modify the merit list. Lordship, page 52, para 55.
Yes.
Accordingly, the respondent number 3 is hereby directed to issue a modified merit list of candidates for selection and nomination against central pool of MBBS seat for the state of Nagaland for academic year 25-26, including the name of the petitioner therein at appropriate position in the said list, and offer her a seat for MBBS course under central pool for the state of Nagaland for the academic year 25-26. Lordship, this modified list, suppose we modify, then she may come in between. Then we have already taken the counseling, and counseling is based on the basis of merits, Lordship. So the learned single judge, Lordship, has totally arbitrarily passed the judgment, Lordship. Yes. Then so Lordship, when the petitioner's father is not a central government employee, she has no case. And even she has no locus to challenge the government policy of Nagaland of 9/9/2021. So Lordship, my prayer is that the learned single judge is totally perverse and interference is urgently required. So I pray that the judgment, a common judgment, impugned common judgment and order dated 14/8/2025 may be quashed and set aside, and the two writ petition 134 and 138 of 2025 be dismissed, Your Lordship. That's my prayer.
Just one thing,
Yes.
yes, page 47.
Lordship,
There's para 42.
yes,
Now, only the children of permanent residents, okay, that we know.
yes,
Number two, the employees of the state UT government.
yes,
Number three, the employees of other governments, okay, on deputation.
yes, Lordship.
That's all right. Now the fourth one, the employees of the central and other state UT government.
Posted in and having their headquarters with the state UT concern will be eligible. It talks about the central government employee.
Of the central government, other state UT and posted. What is this? Can you just clarify this?
The employees of the central other state UT government posted in and having the headquarters within the state. Suppose in Nagaland also we may have a headquarter. Say just for an example, the accountant general, the accounts and audit, suppose. And that central government has been posted from a different place and posted to Nagaland. And if he has been posted and if the accounts office in Nagaland has that headquarter, then her children will be entitled, Your Lordship. Yes. But not for the army, Your Lordship, or for the defense. Say like the army, the navy, and the air force.
NCC?
Lordship.
NCC?
No, NCC is just a youth wing of the army, of the armed force.
They are governed by what law?
Lordship, they will be under the NCC Act because they are not a regular, Your Lordship. The NCC is just a youth wing organization.
But he's an army man.
Yes, because the commanding officer is in the rank of the colonel. So the present petitioner father, he has been posted to Nagaland as the colonel on deputation, Your Lordship. Once his deputation is over, he will go back to his regular army, Your Lordship.
Just read this 76. What is this? What is
76. Notification dated 9/9/2021. The governor of Nagaland is pleased to modify government notification number such and such dated 30 May 2026 on the guidelines for selection of candidates to the state reserve seat under various central
See this
seats.
30 May 2016. What does it say?
30 May, Lordship. Huh? Oh, Lordship, this one is pertains to Nagaland, so we have not inclusive
Because if the 9/9/2021 has been set aside, this 30 May 2016 won't
Lordship,
be resurrected.
Okay, Lordship, in 30 May 2026, this category number 4 was not included. Only by 9/9/2021, this category number 4 was inserted. The category number 4, any candidates who drop out, decline after accepting the seat for a particular course will be disqualified for selection against the quota in the subsequent year. However, if he or she forfeits the seat and the seat is filled by a replacement, he or she shall not be disqualified. In the earlier, everything remains the same except this category number 4. By this notification, category number 4 was incorporated, Lordship.
So this number 4 was
Inserted.
Yes, inserted, yes, Lordship.
So under the category 1, 2, 3, he will not come in.
He does not come nowhere, Lordship. So he has no locus even to challenge the notification 9/9/2021, Lordship.
Anything else?
Lordship, that's all. And after the submission, then only I may
No
reply.
citation, nothing.
No citation, because the only question before this court is the question of whether he is yes,
Whether he is a civil,
Yes,
a
that's
civil
all.
office or a defense.
Yes, that's all.
Defense service office.
Yes, only when he passed that one, only the subsequent submission will come.
Yeah.
But he has to satisfy on that, Lordship.
Yes.
May I assist, my lord? My lord, the key issue which summed up in one sentence, my lord, is whether the state is empowered to change the qualification criteria put forth by the central government. That is the key issue. Now, my lord, to answer my friend's query or her argument that the gentleman, my lord, who was sitting here, the father of respondent number 1, is not a central government employee. My lord, I have to refer again, my lord, to the letter dated 28 July, which allots seat to the state of Nagaland from the central quota. My lord will kindly have page number 57. This is annexure 4 of their appeal.
No, you're saying that whether the state can modify the central government notification.
Correct. That's the
Well, which notification?
My lord, the notification
notification?
allotting the seats, my lord. This is the one that I am just showing, my lord.
Okay.
Page 57, my lord. My friend had taken your lordships through the first portion of this notification.
It's 2-1.
I'm sorry, my lord.
2-1 you wanted to show.
My lord, I wanted to show 2, 1, and my lord, the 4 categories which are mentioned there.
Yeah, that
There is no distinction between central government employees, employees of the civil services, or employees of the armed forces. There is no distinction. It only says that everyone who is an employee of the central government will come under this category. Now, my friend seeks to introduce this difference in the notification issued by the state of Nagaland, my lord, which is the impugned notification which has been quashed by the learned single judge.
No, it's the same thing.
It's the same thing, my lord. My stress is on.
No, you see, it boils down to this issue that has been raised by the addiction league.
Yes, Lordship.
The issue again boils down to whether you are holding a whether the issue pertains to a person holding a civil post as against a person who's holding a post under the Army Act, Air Force Act.
That's correct, sir. Now that is
that is the issue raised.
correct. That is the issue raised by my friend.
And that is what has been again mentioned here in this page 57 at 2-1. 2-1 has been clearly stated.
May I read, my lord, along with your lordships? My lord will kindly see category 4, my lord. This is 2-1, I'm sorry, 2-4.
Yes,
The employees of the central, other state, UT government posted in and having their headquarters within the state or UT concerned. It doesn't say employees of the civil services. That is the problem, my lord. Today, what
shows that this employees of the central includes
absolutely.
That's the only.
Your lordship, may I, my lord, it has come from the horse's mouth, my lord. An issue of employment will best be dealt by the employee and the employer. Kindly have the impugned judgment, my lord, at page 44, please. Kindly see the submission of the central government. Page 44, para 34. Page 44, para 34, my lord, of the impugned order. Very my lord, these are submissions of the learned Central Government Standing Council continuing from para 33. He submits that the father of the petitioner, being an army officer posted in the state of Nagaland, falls within the category number 4 of the guidelines issued by the central government. That is, he is an employee of the central government posted in and having headquarters within the state of Nagaland. So the employer says that I am his employee. Then again, I will
Only
take
he's saying will do, just like that.
I will take your lordship through the statutory provisions also. My lord, may kindly have the Army Act for a minute. Kindly see the Army Act, my lord. The act that governs my service, that governs my.
Have you given a list of books?
Why haven't you?
Yeah. Then from where do we look for?
But I was under the impression that my lord may have.
Always under the impression. It's under the impression with their client coming dressed for what? Jungle safari or something like that.
Lord may not hold that against me, my lord. My arguments are based
Thank you, but the only thing is that you have to live in, glossing over things. Please do not just say that you apologize and not really mean it.
May I seek permission, my lord, to give that list? My lord, may pass this matter over, my lord. At the second call, my lord, I will have submitted everything with subject to your lord's permission.
You have heard so much.
Yes, what do you want to show?
My lords will kindly have section 18 of the Army Act, my lord. Kindly see what my service constitutes. Tenure of service under the Act. Every person subject to this Act shall hold office during the pleasure of the President. Then, my lord, section 19. Who has the power to terminate my services, my lord? Termination of service by central government. Subject to provisions of this Act and the rules and regulations made under the central government may dismiss or remove from service any person subject to this Act. Now, my lord, who governs my services? Kindly see section 191. Who has the power to make rules? Section 191, my lord. May I read?
Yes.
Power to make rules. The central government may make rules for the purpose of carrying into effect the provisions of this Act without prejudice, my lord, subsection 2, without prejudice to the generality of the power conferred by subsection 1. Rules made thereunder may provide for removal, retirement, release, discharge. Every aspect of my service, my lord, is governed by the central government. I work at the pleasure of the President. Now, my lords will kindly see who the President is as per our constitution, my lord, and as per the General Causes Act. May I refer to, my lord, General Clauses Act, section 2, subsection 8. Section 2, subsection 8, my lord, clause B. Very.
Yes.
Central government shall, my lord, subsection 8. Now I am moving to clause B. In relation to anything done or to be done after commencement of the constitution, means the President, and shall include, my lord, then there are other categories. So effectively, my lord, the President is the executive arm of the central government. There is no distinction between the President and the central government, my lord, when it comes to what the role of the President is.
What is an object behind making that defense quota separately?
Now, my lord, will kindly have the defense quota, my lord. For the defense quota, my lord, the primary allocation is given to wards of people killed in action. My lord, there are multiple priority orders in that notification. I fall under the 8th category. So therefore, it is not an equally efficacious alternative for me, number one. Number two, my lord, my friend's argument to say that I should have gone under that quota, there is a fundamental problem, my lord. Can today a person, let's say, who belongs to any of the scheduled tribes of any state of our country, my lord, can he be said that you don't apply for domicile under your state, you apply in the All India quota because there is a quota for ST there also? Could that be the case, my lord? I have been provided with two entitlements, my lord. I was given a choice at the very beginning. I chose to apply under the state of Nagaland because I am qualified as per the central government seats. Today, they can't come and say that you have another quota, you go there. That was my prerogative, my lord, my choice. Just like the STs of the state of Nagaland had a choice whether to apply under the All India quota or apply under the state of Nagaland quota, my lord. It is a beneficial provision, my lord, given by the government. Should I, my lord, should that benefit be taken away to me from me because there is another benefit available? That cannot be the argument, my lord, put forward by the state of Nagaland, because they themselves are saying that the domiciles of Nagaland should receive an additional quota in addition to the All India quota for STs. So they can't blow hot and cold on this issue, my lord. Secondly, my lord, the primary contention from my side, even before the learned single judge, was that, my lord, seats under the MBBS program in our country are divided into two quotas. 15% go to the All India quota and 85% have come to the state. My lord is reading something, but I did not realize it.
Yeah.
Now, my lord, the 85% quota.
From where do you get this 85 and 15?
My lord, this has, my lord, come from a long line of judgment starting from Pradeep Jain, my lord, and my friend will also confirm this.
Lordship, from the various sources, we have got 152 seats, but we are only concerned with 42 state quota because we have got 100% seat in Nagaland Medical College. So 85 is for the state, and we have given 15% of the seat to the central government for central pool, Lordship. And we are only concerned about the 42 central pool seats, Lordship, not concerned about the other seats.
So that's not the point of my argument. My argument is only to, my lord, clarify what the situation is and how, my lord, the central pool seats came into existence. So 15% seats reserved for the All India quota, my lord. So for example, my lord, today in the state of Assam, there is one medical college. For that medical college, my lord, 85% seats will be reserved for the state of Assam. And 15%.
I don't think in Assam, I think 50% seats are given for.
My lord, this is the maximum and the minimum, is what I'm saying. 85 is the maximum that can be reserved for the state.
Not what you said earlier. You said everywhere in India.
My lord, that comes from a judgment of the Honorable Supreme Court. My lord, that quota was enhanced from 70% in Pradeep Jain to 85% presently. My lord, let me.
Please, when you talk about data, please be very careful. In Assam, I don't think, in Assam, I think it's 50-50.
My lord, it's not 50-50, that's for sure, my lord. However, I will not advert to the numbers because, my lord, I also will not have the exact figures. But the point of the matter being that, my lord,
It's not 50-50.
no, it's not, my lord. I'm pretty sure of that. Because no state.
I have the additional AG, one official AG Assam in my chamber last week. I specifically asked him for this meeting. And this is what he told me.
My lord, in that event, my lord, I will withdraw that submission. I will just advert to the issue at hand, my lord.
Please don't gloss over things.
My lord, I will allow me to then come to the issue at hand. My lord, today, ignoring, my lord, whatever percentage of seats are there, the seats, the 42 seats that are in dispute before this honorable court, my lord, admittedly belong to the central government. They don't belong to the state of Nagaland. They have been allocated to the state of Nagaland by the central government, by way of the letter, my lord, that I have just shown. Now, my problem, my lord, is twofold. Your lordships will kindly come again, my lord, back to that letter at page number 57, just for a minute. One key condition has been reiterated time and again. While allocating the seats, my lord will see, this is 2 Roman numeral 5, my lord, clause 2, subclause 5. May I read?
Yes, sir.
The selection of eligible candidates will be made as per guidelines issued by this ministry's letter of even number dated 28 July. Therefore, the seats have to be distributed amongst the candidates as per the guidelines issued by the central government. Now, my lord, may I kindly and take my lords back and forth with a couple of documents. My lord will kindly see condition 2, Roman numeral 2. The children of central, state, UT government employees aforementioned should be treated at par with local residents. Overwhelming, my lord, stress is laid that you will not differentiate on the basis.
Issue here.
No, it is,
That is not an issue.
My lord, let me show that. It is an issue, my lord. That is why it was quashed. Let me show that, my lord. Now your lordships will kindly see the guidelines that have been issued. My lord, which start from page number 71, I'm sorry, my lord. Page number 71 are the guidelines, which are referred to in this very letter. My friend had read 1.2 for your lordship's benefit. My stress again is, my lord, on the residuary para of 1.2. The children of central, state, UT government employees should be treated at par. Now, my lord will kindly see the impugned notification at page 76.
Where were you reading? 71, 1.2?
1.2, my lord, the residuary portion, my lord, the unnumbered para.
Yes.
The children of the central/state/UT government employees aforementioned should be treated at par. And the aforementioned are, my lord, the same as were there in the letter that we had just read, which does not distinguish between civil services, military services, etc., etc. Now, your lordships will kindly see the impugned notification, my lord, issued by the state of Nagaland at page 76. My problem is twofold, my lord. In category 3, this is clause 1, category 3, your lordships will kindly see subclause B. Children of non-local state government employees and children of all India services born on Nagaland cadre to be eligible for category 3B. And then there are additional conditions. One being the candidate should have appeared/passed class 10/12 or equivalent from any of the schools within Nagaland. And number 2, his or her parents should have been residing and posted in Nagaland for at least 3 years or more. And then they say both criteria have to be fulfilled. But the problem here is, number 1, the central government did not restrict those seats to all India services. The state of Nagaland has restricted that. Number 2, the central government did not prescribe any minimum residence period or the condition that class 10 and 12 has to be passed from the state benefiting from the central pool allocation. Then the other problem, my lord, that comes, in effect, what Nagaland has done, my lord, it has reserved 100% of the seat based on just residence. Kindly see, my lord, clause 2, subclause C. My lord, 15% seats in clause A are reserved from backward tribes. Then clause B, persons with disabilities, 5%, and then kindly see clause C. The remaining seats, my lord, talks about every other seat, shall be filled up amongst the candidates belonging to the indigenous scheduled tribes of Nagaland, securing minimum qualifying marks, including candidates belonging to backward tribes. So all other seats will first go to indigenous tribes. Now kindly see what my status. Nagaland has basically treated me like a second grade person. Kindly see clause E, my lord, of clause 3, the selection procedure. If seats are available, after selecting all eligible and qualified candidates belonging to recognized indigenous tribes of Nagaland, then selection of candidates under category 3 will be considered. This is 3E. After selecting all eligible and qualified candidates belonging to recognized indigenous tribes of Nagaland, then selection of candidates under category 3. So one my lord, they take me out of that category by imposing 3 conditions. 1, all India services. 2, 10th and 12th in Nagaland. And 3 years posting minimum. Then, my lord, even if someone fulfills these conditions, even though central government did not contemplate so, even if someone fulfills these conditions, they are only going to get a seat if the indigenous tribes of Nagaland have taken their pick and something is left. Whereas, my lord, the central government repeatedly has laid emphasis that they cannot be treated differently. They have to be treated at par with local residents. This was the problem, my lord. This was the fulcrum that convinced the learned single judge that this notification is improper. Now, my lord, my second leg of argument will stand on, my lord, one judgment of a coordinate bench of the Tripura High Court, my lord. similar issue had arisen, my lord. There was a conflict between the center and the state. May I, my lord, pass on those judgment? Your Lordship, this is Olivia Das Gupta's judgment passed by a division bench of the Honorable High Court of Tripura. Your Lordships, the challenge is mentioned at para 5, my lord. There were multiple writ petitions disposed of by the common order. Exactly similar issue, my lord, arose in one of the writ petitions therein. Your Lordships have para 5 at page 2. May I read? By means of writ petition civil 376 of 2014, the petitioner, Ms. Olivia Das Gupta, has challenged the application of Tripura Scheduled Castes and Scheduled Tribes Reservation Act 1991 to these 5 seats being filled up from the central pool. MBBS seats, my lord. Similar issue as ours. Now kindly see, my lord, the Honorable Court considered what is the nature of the central pool seats, and this clarifies the entire issue. Paragraph 9 onwards, my lord, at page 3.
Yes.
My lord, sum and substance, para 9 and 10, my lord, the Honorable High Court. If, my lord, I am allowed to read para 10 once again for the benefit of your lordships.
Yes.
No doubt, these 5 seats, one in each of the 5 medical colleges mentioned above, have been allocated to the state of Tripura. However, this allocation has been made by the Government of India, Ministry of Health and Family Welfare, via its communication dated 2/9/2014. In the subject of this communication, it is clearly mentioned that these are central pool seats, MBBS and BDS seats. These seats have been allocated not only to the permanent residents of the state UT concerned, but also to the employees of the state and UT governments concerned, and to the employees of the central state UT government employees posted in the respective states. Therefore, these seats are not meant exclusively for the domiciles of Tripura. They are meant for all those who reside in Tripura, including the children of central government employees. Now, my lord, the conclusion in this judgment, my lord, will kindly see page number 4. My lord, this is the bottom portion of paragraph 12. Second line at page 4, my lord. May I read, my lord? We are of the considered view that these seats, being central pool seats, will be governed by the terms of the letter of allocation of the seats. That is the central government letter. These seats are not seats in colleges run by the state of Tripura. No doubt, these seats are to be filled in and on. Then, my lord, just to lay emphasis on this point, my lord, if I am allowed, my lord, to traverse to para 13, my lord, this is the seventh line from the top, starting from therefore. Paragraph 13, my lord, seventh line from the top.
Para 13 of what?
Of this judgment, my lord, the same judgment.
Yes,
Para 13, my lord, seventh line from the top starts from therefore, my lord. May I read?
yes.
Therefore, we clarify that the law as of today shall be that the seats in the central pool or the central quota.
Well, you see, one thing we are very clear also is that the notification issued on 31 July 25
Please, my lord.
will have to be followed.
Correct.
Now the issue is whether the post that you are claiming, whether you'd be entitled to that. That is the sum and substance of what has to be decided.
Agreed.
Now whether you might, you see, you are a central government employee, but does the notification of July 25 relate to defense personnel? And what was the object of releasing these 42 seats to the state?
May I show that? My lord? May I show that purpose, my lord? Please. Kindly see, my lord, this is the letter dated 31st July, my lord, page 57, where the seats are allocated. The same letter. It mentions why these seats are being allocated.
That we have gone through. Yes.
No, my lord, that one para has been left out, my lord.
Yes.
Kindly see, my lord, clause 4 of that letter, my lord, at page 58. Mentions the purpose also.
No, that's all right. But whether the employees of the central government would include you, though you have tried to show us in terms of the General Clause Act and the Army Act, that you are a central government. Your service under the central government. The issue is basically whether this post is relatable to persons who are working under civilian post or under the army or
May I try to answer that?
under the armed forces.
You answer that, then everything will be
Just, my lord, my answer.
Nothing else.
My lord, then I fall back to the basic principles of interpretation. My lord, what is plain and clear from the language of a text, my lord, has to be read in that manner. There is no distinction between civil, my lord, defense, or any other service, including all India. Can the state of Nagaland today say that civil services are only all India services, as they have done in their notification?
They haven't said.
They have, my lord. May I take your lordships to back to that notification? My lord, my argument then will rest and fall back on two things, my lord. One, the notification itself which prescribes this quota does not differentiate between civil services or defense services. Number two,
It says central services.
that's correct. Employees of the central government.
Whether you belong to central service, that you convince us.
My lord, then again, I have to fall back on section 18 of the Army Act. Because I am working at the pleasure of the president. The president is the executive arm of the central government. The central government has the power to terminate my services. No one else has that power. My lord, I am being paid under the 7th Pay Commission, which is again, my lord, something determined by the union government. Central Pay Commission, my lord. Yeah. Well, the budget of the defense services is also passed by the union government. My lord,
Under the Army Act, what is the definition of officer there?
officer, my lord, section 3 of, may kindly see. My lord, section 3, clause 18, my lord. Harry, officer means a person commissioned, gazetted, or in pay as an officer in the regular army and includes an officer of the Indian Reserve Forces, an officer holding a commission in the territorial army granted by the president with the designation of rank corresponding to the officer of the regular army who is for the time being subject of this act. Then, my lord, C, an officer of the army in the Indian Reserve of Officers who is for the time being subject to this act. Then D, an officer of the Indian Regular Reserve of Officers who is for the time being subject to this act. Then F, in relation to a person subject to this act, when serving under such conditions as may be prescribed, an officer of the Navy or Air Force, but does not include a junior commissioned officer, warrant officer, petty officer, or non-commissioned officer. My lord, but in regular parlance, my lord, from the post of lieutenants, my lord, they are considered as officers, right up till the very top of the army. And may I again, my lord, just to answer that question and, my lord, to supplement my arguments, may I take your lordship through Article 310 of the Constitution? Because Article 310, my lord, talks of both services, civil and defense, in the same breath. They are admittedly the services of the Union, my lord, and that is the title of the chapter, my lord. This is part 14. Services under the Union and the states. Part 14, Article 310. My lord, the rules that govern my service are also, my lord, implemented, enacted under this part, my lord. Article 309 gives the power to the central government to determine what the service regulations have to be. All army regulations, my lord, fall under 309. 310, if my lords will have the very first clause. Except as provided by this constitution, every person who is a member of a defense service or of a civil service of the Union or of an all India services, all three, my lord, of the Union, holds any post connected with defense or any civil post under the Union, holds the office during the pleasure of the president. So, my lord, not only me, civil services and all India services are similarly placed employees of the Union. And that is what the Union government has reiterated in their stand, that I am their employee. I am eligible under that notification. And today, what has fallen, my lord, as a result of the notification that was impugned before the learned single judge, is that, my lord, despite being number 2 in the merit list for state of Nagaland, I have not been given a seat, my lord. Merit has become a casualty. 100% reservation has been made, my lord, which is not acceptable under any criteria, my lord.
Anything else?
My lord, that is about it. May I just, my lord, show one last issue, my lord, because that conflict, if my lords are otherwise satisfied, my lord, then I have nothing more to say, because the conflict between the center and state, my lord, center will prevail. This, my lord, medical education is an entry under the list 3, my lord, concurrent list, article entry 25. Therefore, my lord, in a concurrent list, even otherwise, if the center is prescribing something, the states can't override it, my lord.
This is a central seat.
Absolutely.
So the guidelines laid down by the center will take precedence.
Absolutely. That is the, my lord, long and short of my argument. Therefore, they could have neither excluded me nor, my lord, given a preferential list, even when the central government says that everyone has to be treated at par. So both those things, my lord, they are at fault in my humble opinion.
Yes.
That's it.
Lordship, just a few clarification on it. Lordship, only when he qualifies that he comes within the category of central or government employee, then only he can challenge the notification or the reservation policy of the state government, Lordship. So long as he could not satisfy this court, then whatever he say is immaterial, Lordship. And my learned friend has just pointed out with regard to the submission made by the CGC in the judgment and order, page 33, Lordship, 44. At page 44, para 33. Here, the CGC, he has stated that the
Page 33.
page 44, para 33. Yeah. Lordship, it would be at para 34. The submission of the CGC. That he is para 34.
Yes.
He is an employee of the central government posted in and having headquarters within the state of Nagaland, Lordship.
Yes.
That is the submission made by the CGC. But your Lordship, it is only his submission. He has never received the instruction from the Union of India. Lordship, may come to page 5, para 6. Yeah. Para 6, page 5. I have stated here. Page 5, para 6. Page 5, para 6
Page 5 of what?
of the appeal memo. Yes. As your Lordship got it.
Yes, yes.
In the course of hearing of the writ petitions on 6/8/2025, the CGSC was directed to obtain instruction, and if no instruction is received on the next day fixed, the matter to be heard without Union of India's affidavit, considering the urgency of the case. When the matter was taken up for hearing on 11/8/2025, the CGSC submitted to the court that he has not received any instruction from the Union of India. So whatever he has submitted is a wrong submission and without the instruction from the center. So, your Lordship, with regard to the judgment of Tripura High Court, which was relied by my learned friend, is not applicable to the present case. And my learned friend has talked about even the reservation policy. If you see at the reservation, the guidelines given by the central government, your Lordship, may come to page, Lordship, that is at page 71. Who are the beneficiaries stake and for what purpose is clearly mentioned here in the letter dated 28 July 2027. Page 71. Guidelines for selection and nomination of candidates against Central Pool MBBS BDS for the academic year 2025-26. Selection of candidates by beneficiary stake union territories. 1.1 beneficiary stake UT. The stake UT which are deficient in medical education. Then Lordship may come to 1.5, that is at page 72. Page 72, 1.5. This talk about reservation. The reservation policy being followed by concerned beneficiary stake UT will apply on Central Pool MBBS BDSC. So the union has given us the power. Whatever reservation policy we are following, that will be applicable to the Central Pool MBBS. So for the last 5 years, because the latest notification is 2021, we have never received any complaint from the Union of India regarding on the reservation policy. Then with regard to the article.
What is the reservation policy?
Lordship, at page 1.5, that is at page 72.
No, where is the reservation?
The reservation policy, that is at page 76. This is our office memorandum notification where the learned single judge has quashed. We have reserved the seat for the backward tribes of Nagaland, person with disability, remaining seat for the Lordship candidates belonging to the indigenous scheduled tribes. And after, if the seat remains vacant, after selecting all these people, it will go to the other candidate, Lordship. So only when the petitioner qualifies that her father comes under, then only he can challenge whatever right or wrong, your Lordship. But if he could not qualify, he has no locus to challenge. And with regard to Article 310, what my learned friend has said is only about with regard to the disciplinary proceeding, your Lordship. So, your Lordship, my humble submission is that there is a perversity in the judgment, so the interference of this honorable court is urgently called for. And Lordship, the admission, the last day is drawing nearer. So my prayer that it may be, Lordship.
When you read the guidelines,
Yes, Lordship.
when the employees of the state UT government, say number one. Number
Yes.
two. So it will not apply to defense at all.
No, it doesn't apply to defense.
The
If at all, it applies to defense. If central government, the army comes under the meaning of central government employee, then there could not be a provision for the defense personnel, Lordship. 42 MBBS is for the defense personnel, Lordship. If at all, that comes under the meaning of central government employee. That does not come under that category. That is why the Union of India has categorically reserved 42 seats for the defense personnel, Lordship.
Yes.
Now, lordship is to decide lordship whether the respondent said lordship allowed to admit in the quota which was reserved for the
No,
central
that
government.
we know what we have got to do.
Otherwise, lordship,
We
in the
want to know what is your instructions.
notice was
You have
not,
got to take a stand.
notice was not issued, otherwise, I have no, otherwise, lordship, as per the constitutional prescription and statutory lordship prescription. There is no doubt it is central government employee, lordship. But whether that particular even specifically mentioned that defense personnel quota is 42, whether he comes to that 42 seats or other seats, lordship, that part lordship to decide. Regarding employment part, lordship, there is no
See,
dispute.
You see, that is the problem now.
Loss.
You see, if the state of Nagaland has been given 42
Loss.
for the central and other state,
Loss.
why is it separately the Ministry of Defense has been given?
Defense 42 seats are all in the total. All in
For
the
what purpose?
lordship.
For what purpose have they been given this?
Under the persons, the words which belongs to the defense personnel.
That much we know. Cannot have to be
Personnel-
what? Cannot be
defense
anyone.
personnel and the
Other or anything. Has to be for the ward. Why? Why for the ward? What is the objective of giving that protection? For whom? For the wards of only 42. Why only 42?
42 cities for the civil services, that part is the central government services. And another 42 seats is specifically mentioned for the defense personnel. My point is that, lordship, when there is a specific seat allocation is there, lordship, whether he comes to that other seats or not, that part, lordship.
That's why we want your help.
That part, then I have to obtain, sir. Otherwise, I am
Because you have got to take a stand either this way or that way.
Now, regarding central government employee, there is no dispute. Lordship. He is a central government employee as per the constitutional provisions and the statutory prescription of the Army Act.
Central government employee, why separately for the defense?
That's why I just.
Yes, then that will also come here.
That's why I indicate, lordship. There is a specific seat allocation is there for the defense personnel. Whether
Extra seat.
extra seat is specifically allotment is there, whether that category persons also come within that or not. That part I have no instruction. Otherwise, specific mention is there. 42 seats is as per the defense personnel. And regarding
They have a choice. They can go there and they can go.
that part today I cannot. Otherwise, he is a central government employee. There is no dispute. If go by the constitutional provisions, if we go by the Army Act also, lordship, it is there. He is a central government employee. Even lordship, if we go by the lordship that the provisions of the CCS, then paramilitary persons come within the category of that state service. If we go by the submission made by the lordship learned traditional as lordship, then paramilitary persons will include that 42 quotas. As because he has relied that he is not belong to the CCS rule is not applicable here. He relied the definition clause of the CCS rules. Otherwise, Army rules is very specific, lordship. Even constitutional provisions is also very specific. He is a lordship central government employee. But lordship that 42 earmark seat is there for a defense personnel. Whether they can also in that category that part I have mixed.
Madam, what about these paramilitary forces?
Paramilitary is not an armed force, your lordship.
So where will they be? They will come under this, they can apply for this Nagaland seats or not?
If we go by the submission that
if the Army Act, if the Army, Navy and the Air Force
Yes.
would have to apply for those 42 defense seats.
Lordship, as per the schedule, who are the central government employees only mentioned in the.
No, but then what about CRPF, BSF, Assam Rifles?
And CISF also worship.
CISF,
ITVP also worship.
where will they apply?
Lordship, here. Who comes under this act, Your Lordship? It is mentioned in the schedule,
Which act?
Lordship,
Which act?
of the CCS classification and
No, we're not on that.
no. But Your Lordship, for the purpose of
No,
this MBBS,
they are central government employees or not?
Lordship, no doubt for there would be a central government employee, but for the purpose of availing the central pool MBBS seat, we are only concerned for availing the MBBS central pool MBBS seat. So whether they comes under the meaning of central government employee or not, Lordship. Lordship may see the
Why won't they come under? They come under. Only thing is that their service rules are, the service rules governing their service are different, that's all.
Yes, the service rule are governing the difference. Then, Your Lordship, if that is the case, then where is the question of allocating a separate seat for this category of person? If that is the case, there will be a preferential treatment.
No, so they're getting a quota within a quota.
No, Your Lordship.
It's a special quota for themselves only.
Your Lordship, this is the central pool for the 56. Your Lordship, page 56 is for the separate departments, Your Lordship. Here, the Ministry of Home Affairs Civilian Terrorist Victim, four has been allocated to them. Ministry of Home Affairs, 26. Discount for wards of Central Armed Police personnel. Ministry of Education, 1 ward of Tibetan refugee. Ministry of Defense, 42 wards of defense personnel. Ministry of External Affairs, 42. Cabinet Secretariat, 6. State of Arunachal, 4. Meghalaya, 54. Nagaland, 42, Your Lordship. So, Your Lordship, if at all, Your Lordship, if the petitioner father says that he qualifies under that central government guidelines, then she would be availing lots of opportunity, which would amount to a preferential treatment.
I think, Mr. Gogoi, you have to clarify this. We have to obtain instruction. We can dispose of, no doubt, but we want the clear stand of the government.
Whether that 42 can apply that to also.
Whether they come under that, whether they come under this clause 4.
Yes, for the purpose of a central pool
Because of the seat distribution. The seat distribution also provides for distribution to Ministry of Home Affairs.
That's why I indicated also.
Everyone, you see, separately. Then, you see, so for education department also, then external affairs also separate, cabinet secretary also separate.
Yeah, that's why I
So,
indicated that
yes,
also.
because of this seat distribution, I think we need a clarification.
Yes.
Because we thought that the CRPF and all, why should they come under? But then they've been again given a separate quota.
Yes.
One including question not arising from the discussion. But had this been the case, that since I have a quota under the Ministry of Defense, I should not get the quota of the state of Nagaland. Should not then this to apply uniformly even to scheduled tribes of Nagaland. Because then they
No,
can't say
that is not the issue right now. We see, we don't want to go beyond the four corners of this thing. We just want to be very clear on the stand of the central government. The central government seats are on the line. The central government notification is the one that we have got to interpret. Central government is not given the interpretation. Let us hear them. Like you said, we have to hear it from the horse's mouth. That horse that you are relying upon is not as a central government horse, but on his own horse he's riding, on his own high horse, whatever. So that we cannot rely. Now let them clarify in clear terms. That will clear everything.
Also.
That because of the seat distribution.
Yes, may I only request for 22nd September, the course will start.
So what? Today's what day? Today's 8th. So within 10 days, or within a week, complete instruction. Right. The issue to be decided is with regard to whether clause 4 of the office memorandum dated (28/7/25) would include army officers. Full stop. Clause 4 of the OM dated 28/7/25 states as follows. Inverted comma, the employees of the central slash other slash UT government posted in and having their headquarters within the state slash UT concern will be eligible. This is page 47. While it is the case of the state of Nagaland that the said clause only pertains to central government, only pertains to federal government officers holding civilian posts. It is the case of the respondent that the same also includes officers holding posts under the Army Act, under the Army Act. The defense personnel under the Army Act, defense personnel under the Army. It is noticed that the appellant had taken a stand in para 5 of the para 6 of the writ appeal that the submission made by the learned CGC before the learned single bench was without receiving any instructions from the Union of India. Mr. K. Gogoi, learned CGC, shall accordingly obtain instructions with regard to the above and file a affidavit.
I'll only instruct.
I will obtain instructions with regards to the above and submit the same on when?
On 22nd also.
22nd, the thing, we will do it before that.
Then I will turn 19 also.
On 18th. 18th.
I will turn.
18th, This is a matter on 18th.
Today I need one soft copy of the, my may indicate in the order.
What?
So we are in supply the one soft copy of the.
Okay, I'll serve your
I
lordship.
don't have to write it. You supply soft copy.
Yes, your lordship. You can try that, you can try that.
Right.
The previous matter was a very interesting matter.
Only thing now is we have to be decided by court now.
The author will know, Miller, why it was made.
That it should have waited for the author, the main person who is going to decide the entire. Yes.
Miller, this is a case where we're assailing the order of the learned single judge. Miller, actually, we owe some money to the Provident Fund organization. There is no dispute. And there is a certificate of demand also. Now we paid some money Now, my lord, the learned single judge, relying upon an purported undertaking given by us, has, my lord, said that we should pay 5 crore immediately. My lord, if your lordship would kindly come to the writ petition for a moment, what we said and what was perceived by the learned single judge. The writ petition, my lord, paragraph 4, copy of the writ petition starts at page 22. If your lordship would kindly come to page 37. That the petitioner respectfully begs to state that after getting the information that the petitioner's company will get some amount of money from the Minister of Defense, kindly mark this, my lord, the respondent number 2 approached the Deputy Commissioner Kachar, requesting him to pass an order in their favor amounting to 3 crore so and so, deducting from the total amount of money to be received by the company from the Ministry of Defense. That on 2/4/22, respondent number 3 issued a notice of demand to the petitioner company wherein it is stated that recovery certificate white dated so and so has been issued by the competent authority to recover an amount of rupees 3 crore 39 lakhs and odd, details of which have been shown in the form of an XRA. That the statement shown in the annexure A is incorrect as the respondent authorities has calculated amount in the wrong way. It is to be mentioned here that although the respondent authorities have been pressurizing the petitioner company to be the said amount, however, they have not deducted the amount received by them in between. That as per the calculation of the petitioner's company, they have to pay an outstanding amount of rupees 2 crore 80 lakhs and odd, and there is no outstanding amount for the year 2013 to 18 as claimed by the respondent. My lord, if your now lordship kindly comes to the impugn order of the learned single judge, my lord, please come to page 112. Now, the learned single judge, my lord, refers to para 12 and 13 of the writ petition, but 12 and 13 must be read in conjunction with para 4, which I read. Petitioner company in the present proceeding in paragraph 12 had made the following contention. Further, the petitioner has given undertaking that Air Force Authority has acquired 150 acres of land of their company, and they will get a handsome amount as value of their land, and immediately after getting the money, the petitioner will pay the entire amount at one go, but respondent authorities has not at all considered the reality of the petitioner's company and have been issuing one after another order mechanically and finally issued the impugn order. Then para 12, my lord, that the petitioner has clearly undertaken that they will pay entire amount at one go immediately after receiving the value of the land acquired by the Air Force, but the respondent authorities are quite adamant and had issued the impugn notice dated so and so. My lord, actually what happened in between, my lord, we also got some money for other acquisition. In fact, my lord, there was already a letter. I do not know why Deputy Commissioner's establishment has not acted on it. Now, before that, I'd like to place this statute, my lord, why the Deputy Commissioner has the power.
No, you are against this order.
No, what I'm saying is this Air Force money we have not got as yet. We're in the process. Recently, we got a communication. I'll just show the legal provision, my lord. Please come to 15F. In fact, in terms of this, Deputy Commissioner has been already approached. 15F, my lord. Notwithstanding the issue of a certificate, as in the case, certificate of demand issued to the recovery officer under section 15B, the secretary cum provident commissioner or any other officer authorized by the board may recover the amount by any one or more of the following modes. If any amount is due from any person, that is the Air Force, to any employer, that is the petitioner who is in arrear, the secretary cum provident commissioner or any other officer authorized by the board in this behalf may require such person to deduct from the said amount the arrears due from such employer under this act, and such person shall comply with any such requisition and shall pay the sum so deducted to the credit of the so and so. So, my lord, in fact, they are competent. If they know that the money is due to the, my lord, defaulting T state, then they can straightway write. In fact, if your lordship would kindly come to page City Demand, yes, notice of demand, page 60, my lord. No, city, no, DCL, sir. Yes, sorry, my lord, page 59. In fact, they have already written to the Deputy Commissioner, my lord, on 33/22, that with reference to the subject cited above, I have the honor to bring to your notice that the management of Polar Bond Tea Estate has been defaulting in deposit of Provident Fund due to the tune of rupees 3 crore so and so. As informed by the garden management, the undersigned has come to know that Government of India is planning to acquire land from the management of Polar Bond Tea Estate against the management will get payment from the Government of India through District Administration of Kachar. As such, I hereby request your honor to kindly pass an order for payment. So there is already a request, and my lord will kindly see this is what we got recently from India. Only on 7/8, my lord, we have been informed regarding this. So they can attach this money, my lord. We have no problem. Kindly see, my lord.
The problem is the documents that you submit are so bad. Just read
Yes.
this 59, just give it to him.
The extra, we have changed that, my lord. We have given extra paper book.
I don't know, we have not changed it yet.
No, but we have given an extra paper book. Same paginations, my lord. Also, but recollect this matter was moved, and because of that only now we have changed. Yes.
59.
That is a letter under 50-.
Yes. As far as I know, you had put this demand of 3 crores under challenge in the writ petition.
Actually, my lord, we say that we are in the process of getting money. As soon as we get it, we'll pay. In fact, now only communication has come after filing of the writ petition, my lord. 4825. Kindly have a look at this. That is the Air Force land which we mentioned in paragraph
7/8.
4, 12 and 13.
7/8.
7/8/25. With reference to the subject mentioned above, I am to inform you that Defence State Officer Guwahati has submitted proposal for acquisition of land measuring so and so for Kumbhirgram Air Force Station, which pertains to so and so. You are requested to issue NOC for acquisition of land from the concerned tea garden. In this context, it is to be stated that LA compensation will approximately amounting to 14.38 crore. So, my lord, already Deputy Commissioner has written, PF Commissioner has written to Deputy Commissioner. Then from this amount, they can deduct our due straight away, my lord, which will be getting very shortly. But learned single judge has taken note of an, undertaking which was given in respect of this money, my lord, not in respect of other money. So some miscommunication, my lord. We never, because para 4, 12 and 13 has to be read together. Para 4 of the writ petition, that's page 37, we say that we owe money from the Air Force. As soon as we get it, we'll pay. These are all 150 crore property, my lord, for default of, my lord, 2-3 crore. How can my...
No, but I believe now your the amount, your default amount has risen.
No, my lord, there is one problem, my lord. Let us be very clear about what we are concerned with is this certificate M. What they have enforced is this certificate M. For subsequent use, they can always come up with other proceedings, my lord. But for the present, we are concerned with certificate as mentioned in 7/3/22. That is 3 crore and odd. Out of which, my lord, we have paid. Now, according to us, 2 crore 80 lakhs is due. 2 crore 80 lakhs is due. Because when we approached this honorable court, there was an order we should deposit 50 lakhs, which we did. So my humble submission is, my lord, as soon as they can now even, what do you call it, attach this amount also.
Your Lordship, while the writ petition was moved, the petition was moved only on the ground that they are about to receive some money. And it was a mercy petition. The first prayer was that they need certain time. The prayer was to grant some time to pay. And accordingly, they were asked to pay certain amount for interim order. Now, instead of the Air Force property their own garden has been acquired and they have received a compensation because of this court about 7 crores. And after the interim order passed by this court in the year 2023, apart from the demand that is due and payable under the demand notice, they have stopped paying the PF dues as and when also. From 23 to today, they have not at all paid any PF dues. So along with the PF dues, because we cannot take any action against them because of the interim order, because they have been stay on the proclamation of sale. So because of that, they have taken advantage of the interim order, not paid any PF amount. And along with the interest, now the present PF dues is about 10 crores. So now that is
why don't you, have you made a demand to them for that?
we cannot issue a demand notice because there is a stay.
No.
There is a
They-
stay
no,
because
my
the
lord,
proclamation
I'll
of
clarify
because there
one
is a
thing, my lord.
proclamation of sale. After the demand notice, we have issued the proclamation of sale. So since the proclamation of sale is stayed, how can you
Let us see the order. Where is the?
Yes.
Your lordship will see at page. Your lordship will, the first interim order is at page 89. And the 92. Page 92, your lordship will see at paragraph 10. Taking into account the above, this court stays the notice for settling a sale proclamation dated so and so till the next day, subject to deposit of 15. So sale proclamation is subsequent to the demand notice. So since the entire process has been stayed and they have come to this court.
Now what has happened to this?
This order is continuing as of today. Only because they have paid that amount of 130 crores odd. 1 crore 30 lakhs.
What about this last order of
So
104?
So since they have preferred an appeal, because it was supposed to be automatically vacated if they don't deposit the amount by 5th of September. But since there is a preferred an appeal before this honorable court, as a matter of probity and fairness, we have not taken any action. That is why, see, from 23, there was no bar on them to stop paying the PF, at least the current PF. And because of the accumulation of the PF along with the interest, now it's about 10 crores. And your lordship recently, because of non-payment of bonus, wages, which we are not concerned. However, because of non-payment of wages, rations, there was a dharna and blockage of highway. There's an assistant labor commissioner letter to the labor commissioner and also to the DC. Because they have received this money, look at the conduct. They have come before this court asking for equitable relief, and their conduct is they have not paid. They're not even paid the wages and rations also.
Yes.
I'll just
2439, another writ petition. This is a different writ petition.
Which one, your lordship?
2439.
2439, yes.
Yes, different.
This is the money your lordship will have this order. This is the money they have received. 2439, your lordship will see. Page 2. So they were supposed to receive some land acquisition compensation for land acquired from the garden. And see at paragraph, third paragraph, 9/5/2025.
Yeah.
They have received around 7 lakhs, 7 crores. They have already received this amount. And now they are saying, since I have made a prayer that I will receive the money from airport authority acquisition, I will not pay this amount. This is their prayer. And these are ultimately they have deducted from the wages of the laborers and they're not paying. So in the interest of justice, the learned single judge has equitably classed this, at least pay deposit 5 crores which you have acquired, which have got now. Their contention was they didn't have money at that period of time. They have now. And they are enjoying the stay for which we are not able to take any action.
Milord, my reply is very simple, Milord. The letter of Provident Fund was there at page 59, which I've already shown, Milord. This is,
And one letter, the labor commissioner, assistant labor commissioner that has sent that passed to the lordship, dated 6 September. It's one page letter, which is
Yes,
Assistant Labour Commission written. May I read this letter?
yes, yes.
On 6 September 2025, the workers and staff of all the 5 divisions of Polar Urban Tea Estate conducted a road blockade and strike owing to non-fulfillment of statutory obligation like wages, ration, etc. on the part of the management. Prior to this office has conducted multiple conciliations. However, none of these conciliations were honored by the management. Resultingly, our Section 12 for failure report has under Industrial Dispute Act on various labor issues, including non-payment of wages, ration, salary, and area wages at Polar Urban Tea Estate was sent on 19 May 2025 after getting this 7 crores, Your Lordship. Further, a case under Section 1217 of the Plantation Act 1951 was filed against the management of the Polar Urban Tea Estate before the Honorable Subdivisional Judicial Magistrate Lakhimpur, Kachar on 13 March 25. Post that, a case under Section 9 of Plantation Labor was filed on 9 May and Section 10 of Plantation Labor by this office owing to the violation under the same. In the last discussion held on 29/8 between the district administration, the workers' representative and this office, it was noted that 13 weeks of rations are pending and payment of wages has been irregular. It was pointed out that although wages are usually due on Monday, they are often delayed and not paid on time. The managing director over phone committed that the pending wages and ration will be provided on time, but that was not honored. Resultingly, the workers called strike today on 6/9/20. The management refused to provide the weekly wages today, which was due on 1/9/25, and did not agree to the workers' demand. Post to the intervention by the District Commissioner Kachar and this office, the management agreed. So they have agreed to a thing. Further, the salary of the staff of the last 5 months are still remains pending. Moreover, as per the government advisory, the bonus negotiations was to be finalized by 31/8/2025. However, till date, the bonus negotiation has not been settled by the manager. Your Lordship, because of the entering Puja holidays, they are supposed to get a bonus. And if the bonus are not given on time, then there is, Your Lordship knows what the workers then resort to. They have already resorted to blockage of the highway. So my humble submission is that since they by the conduct, they have received this. Now their prayer is, I will receive that amount. We don't know what is they've received or there is a litigation on that. And then again, we'll have to wait another 2 years. So since this amount has already been received by them, let them deposit it.
Yes.
Yes. Because my first submission is, even if there are subsequent demand, they can always come up with subsequent certification of demand. We are concerned with certificate of demand dated 7/3/22. We have not questioned their authority to, my lord, if there are dues, they can always come up with another. So first come first, my lord. Please come to page number, my lord, 60, my lord.
Yes,
This is the notice of demand. And one by one.
There is one thing.
Yes.
Your demand is only for the 3 crore.
Yes.
Then you make the demand for the others.
Yes.
Your Lordship, the stay of this order.
No, my lord, why stay is not in respect of subsequent demand.
No.
Why should your lordship clarify that, my lord?
No, we take away the stay because for payment of the remainder.
If it is there, Lord, my instruction is, my lord, what happened? My lord, lordship will kindly appreciate one thing. The industry as a whole is going through a very bad phase. First of all, my lord, after the change of, no, I'm just giving an example. No, my lord, it has got something to do with our ethos also, my lord. Kindly see, my lord, tea industry, after it has fallen into a particular class of businessmen, my lord, it has gone to dogs. For the simple reason, they are after profit. Now, when it was, my lord, Agency House Gardens, it has got a different flavor altogether, my lord. Not only on the quality of tea, only on the business also. Now, the Agency House Gardens are no longer there. Typical Indian businessmen have bought over the tea gardens. Therefore, my lord, a lot of problems are going on. Secondly, my lord, right from COVID 2019 to change of climate, my lord, it has got a serious impact. And on top of that, in Barak Valley, my lord, the amount of land that has been acquired from the gardens, they're in a very difficult situation. Now, on top of that, this Provident Fund organization, my lord, they have made it a point to make business out of this. My lord, I'm handling cases. No, please, have the patience to listen.
This money
Then,
left.
no, have the patience to listen. You'll get your chance to reply. Then, my lord, they're appointing persons as receiver, my lord, who doesn't have any experience. And the receiver, my lord, I am contesting in 3-4 cases where I have challenged the appointment of the receiver, my lord. Now, therefore, what they are doing, my lord, yes, they have right to recover. Statute has given them power. That's why I said, my lord, age 59 letter was there. Why Deputy Commissioner did not deduct that amount? I could not have come in the way, because Section 15F says if any money is due from the employer, then they can approach the Deputy Commissioner. They did in 22. And my lord, our intention in the writ petition in paragraph 14 and 13, 12 and 13 was in respect of Air Force land. That money we are getting now. Let them, the moment they get it, let Deputy Commissioner attach the amount to the extent of 3 crore 39 lakhs. That is the certificate amount.
You right now, but you have got extra money.
No, my lord, we have given, my lord. We have given Kiman Dilu in the meantime. What can I do, my lord? I can pay 50 lakhs another amount now. And as soon as this money gets, they will, as far as this certificate is concerned, let them adjust it at the source.
What is you haven't made a demand
Not
beyond
for the subsequent period.
Subsequent, we're not able to because of the order.
Sorry?
because of
The interim order.
No.
we'll modify that interim order. You can give a demand.
Huh.
That cannot be stopped.
Yes.
And lordship, this
No,
amount, of 12 rupees from the workmen, they've already deducted. This is not that amount which is out of profit they have to pay. The amount they have deducted from the wages. Look at that. This money is not ours to make profit. This money is for the workers that we have to give. And then, your lordship, there's one more issue that is troubling the PF. One is that since they are not being paid, the workmen, they are retiring from their garden. So we adjust from the dues that have already been, the other gardens, other workmen who are clearing their dues. So sometimes for the ends of justice, we pay from that pool. So if till then, if your lordship is inclined to pass in interim order, if the work, because there is a code assigned to each workman and the garden, since they are not clearing their dues of the PF, if any workman retires, then we are not bound to take it from the other pool. As and when they clear the PF dues, then we keep on paying. Because now it is a problem for us. Otherwise, then when workman retires, we take it from the pool that we collect from the other tea gardens. If that submission can be
No,
recorded.
my lord, as an OP, you cannot set up a claim in my appeal. Let us be very clear about it. If you have got any independent claim, file a petition or approach the authority. As an opposite party, you cannot take relief in my petition. That's the very fundamental principle of civil law.
Because they are not claiming the pay, we
No,
are
no,
not
no,
bound
no.
to pay.
No. As far as you are concerned, you should defend your certificate of demand. That is 7322. We have assailed only that. Subsequent to that, if there are dues, you are welcome to raise a demand. We have never said. Your certificate of demand is dated 7322, which is for 3 crore 29 lakhs. Out of which we have paid 1 crore 30. 1 crore 39 lakhs we have paid. The rest we are bound to pay, my lord, as soon as we get this.
Oh, you filed an application in the before the single bench.
Yes, we filed an IA.
Regarding the amount.
Yes.
That is there. That is already there.
After considering that amount, the single bench was pleased to pass this order. So because this amount is already in their hand, we don't know when they will get that amount.
No, shortly, very shortly.
Whether they lead to subsequent litigation, we don't know. Or we'll have to wait another 2-3 years again, like in the instant case.
Because there is already a letter written to the Deputy Commissioner, they can pursue that letter where at source, Deputy Commissioner can, deduct it, even without asking us.
Right.
Handed over charge. That is a due now, because after the interim order, they have not even paid the PF and the dues and the interest, which has now come to 8 crores 11 lakhs. Apart from the amount due under the demand notice.
Your only problem with the stay order.
Yes.
No, my lord, regarding the other dues is I have not paid. Let them follow the due process of law. Because we are questioning that 7322 demand. Proceeding is confined to that, not to any other demand. You enforce it.
And their prayer in the writ petition was they need time. So they have got 2 years time and they've got the money now. So what is stopping them from paying them?
Correct. Third, Mr. K. Chaudhary, Leonard Senior Counsel for the appellant. Listed by Mr. J. Kalita. Mr.
Partial.
R. Sharma appears for
As standing counsel for respondent 2, 3 and 4.
appeals for file number 2, 3 and 4.
Yes.
This one. One. Hearing concluded. Order reserved.
Miller.
Obliged.
Seven, my lord. Yeah, in the case, my lord, in terms of the earlier writ, appeal number 5, my lord, we approached to the authority showing, my lord, to consider our case, but they did not accept our,
Fair.
that application has not been taken, my.
No.
Or lordship can give us,
Say here, enough.
lordship
So
can,
we direct that
yes,
in terms of this order pass
my lord,
in WA 5 of 2024, you file an application
my lord,
and let them consider.
my lord, the time limit be given.
Correct. Yes, madam. Anybody here? Yes, madam.
এই মতে দিব আৰু।
আমি রেসপন্ডেন্ট নামে কি
মই আছো ডায়েৰী আসাম ডায়েৰী 1 and 2
Husbandry, my lord, they have their own counsel. Animal husbandry.
They're not here. They don't want to come. What to do? They're least bothered. Can't keep on waiting for them.
at the most we can intimate, my lord.
They're not coming. Right. Mr. J. Barbuya, Learned Counsel appears for the appellant. No one appears for the respondent. The appellant's prayer is for setting aside the judgment dated 10/6/2025 passed by the learned single judge in WPC 7535 of 2022, by which the appellant's prayer for promotion to a grade 3 post had been rejected. The learned single judge, while dealing with the issue, relied upon two division bench judgments of this court, namely Dilip Talukdar and 21 others versus State of Assam and others, 2017, 2 GLT 135, and Kuladhar Talukdar and others versus State of Assam and others, 2021, 0 Supreme, bracket GAU, bracket close 90. Wherein it had been held that regularization of a grade 4 worker against a personal post would not ensure his entry in the encadrement post, which was a feeder cadre for promotion to any higher cadre post. Next part. Mr. Jaya Barbuya submits that the present writ petition can be disposed of in terms of the order dated 14/5/25 passed by division bench of this court in WA number 5 of 2024, wherein a direction had been issued to the state government to consider the application of those appellants for encadrement of their courts, which was like with the government. He submits that though the writ appellant had submitted an application for encadrement of his court, the same has not been done till.
No, madam, they have not received.
They have not received it.
No,
So you have not done it.
because I am not the party in the case.
Oh, you have not done. Okay, what do I think? There, no, let's read the further thing. No, she submit that the
May it please your lordship. So this is an statutory appeal, my lord, against conviction. My lord. The appellant was convicted for life under section 302
Third, Mr.
UU Khan.
You can learned counsel for the appellants who submits that the appellants were convicted under section
302, 323, 323,
like 323,
34 IPC.
like 34 IPC by the Sessions Judge Kokraja in Sessions case number 155, like 2014. By judgment dated
3620.
3/6/2025. Admit the appeal, call for the TC. Ms. A. Begum accept notice on behalf of the state. This is the matter after 5 weeks.
My lord, there is an IA, my lord, for suspension.
Your eye is wrong. Your eye is under 415.
Yes, my lord. We'll correct it.
How will you correct? You file a fresh.
Yes.
You cannot correct by hand. You'll have to make an application for amendment. Better you withdraw this and you file a fresh. 415 is already allowed.
Yes.
With 415, it has to be under 430. Right. We now for the applicant submits that. Page that he may be allowed to withdraw the application with liberty to file a fresh. Under section 430B. The prayer of the applicant is allowed. The IA's witness has withdrawn, come out with liberty.
Deeply out.
Make pleasure, lordship. My lord, in this case, lordship accused is 73 years of age, lordship. As per report of the to the legal service authority, lordship. And lordship, he is nearly ill, lordship, unable 73 of age, lordship.
Dying declaration.
That is also not correct,
Eyewitnesses
lord.
also there. Lord. Two eyewitnesses also there.
But lordship, I am coming only one evidence of PW6, lordship.
Paper book is already ready, Lordship. So it will be hard, Lordship. There's two eyewitnesses, daughter and wife.
That also, lordship. let me
Medical
tell-
is also.
When do you want hearing?
Any day, lordship, he is very old. Anytime he may die, lordship. This week or convenient or subject to convenience of person.
Old, just because he's old doesn't mean that.
No. And there are discrepancies are there, lordship, because there was a first list, there was a GD entry. And after GD entry, PW1 and 2 lordship was examined under 161. That police officer as well as the after.
When do you want to hear? We're ready anytime, now also.
It can, lordship, if other matters can be finished and then my matter.
Other matters will be finished.
Lord.
Not much less.
Lordship. Lordship.
Yeah. Something was.
My lord, data part, my lord, I'm for the petitioner. So I have received their copy, my lord. So I want to file the reply on.
Okay. Okay, right, okay. Mr.
A.Y. Chaudhary.
A.Y. Chaudhary, land counsel for the petitioner, submits, praise that may be granted 2 weeks time.
2 weeks time.
To file.
Reply of affidavit.
To the affidavit. To be filed by the deputy commissioner. This is a matter of. Let it continue with this.
If you
Page. What has happened?
In 13, my lord, we have prepared a review application, my lord.
What has happened?
And review notice was issued, my lord. In the delay condemnation petition, notice was issued, but this is the order.
Review before whom?
Before the division bench, my lord.
My lord, after disposal of writ appeal.
Who was the, before, we judge? That the
Honorable,
earlier order was passed by whom?
Honorable Mr. Chief Justice and Justice Mitali Thakuria, my lord. So,
There.
yes,
So
ma'am.
that will be decided.
My lord, yes, my lord, he may appear before that. I can supply a copy of the review petition so that the review can be disposed of at an early stage and he can pursue the.
Review is not, review petition is not supplied
In fact,
So you give a.
yes, my lord.
Copy is not supplied.
No, my lord. Tomorrow I'll give,
Tomorrow.
I'll give the copy, my lord. In fact, notice was issued in that.
Mr.
K.U. Ahmed.
K.U. Ahmed appeals for the petitioner. N.J. Katania submits that the review petition, that notice has been issued.
In the
The application for condoning the delay in filing the review petition. He submits that the application for condoning the delay is registered as
IA number 2363/2025.
IA
2363.
2363 of 2025. He also submits that he will supply a copy of the review petition and the applications to the council for the petitioner within 2 days.
Yes, sir.
This is the matter. After the changes.
Before
Yes.
vacation.
On liberty.
Second.
Obliged. Right, your lordships.
Lordship, before my senior friend starts, Lordship, this petition objection is not filed because last date another learned people was there, Lordship. So objection for the IA.
Not fine.
Not filed. Lord. I have gone through the record, Lordship. A short date may be given, I will inform her, Lordship.
In fact, my lord, if your lordship kindly peruses the last
Say-
order,
Earlier, all the files are with her, Lordship. Petition copies with her. With another APP.
SH Bora.
Lordship.
your lordship may kindly peruse the, my lord, last order, paragraph 9. That part, my lord, my learned friend has to comply.
Notice already served, Lordship.
Notice.
Notice served.
So notice, sir. Where is the notice of?
Lordship, there is a order, Lordship. IA Lordship.
Yeah. There is nothing in that. Yeah, there is nothing. Notice has been. No, there is nothing from the OC.
Then Lordship, I'll have to send it. Resend it. Presley.
Okay, right.
I have to.
The main approach. As the TCR has arrived, I just need to prepare the paper. Ms. Ebena, the additional paper shall further be instructed from the OC of the concerned police station with regard to the issuance of notice to the respondent number. In the IA, right? Ms. Ebena, the additional paper is granted.
Can it be,
After
can it be before vacation, my?
I don't think they'll be able to make the paper. No?
I would have liked to press the IA, my lord.
Okay, but they're going to have a tough. It's a section 6. Section 6 is not very easy to overcome.
My lord, no, but then I'd like to present my case before lordship, my lord, because here is a case where, my lord, he has been convicted under the, my lord, Prevention of Child Marriage Act. And my lord, the POCSO Act has been, my lord, that has been invoked. He has been given RI for, my lord, 20 years. But then, my lord, there was no complaint from anyone, my lord. It was a suo motu case raised.
How old?
My lord, as per the findings here, my lord, she was below 18 years.
I said, how old?
Now, my lord.
That time?
My lord, at the time of the marriage.
12, 13, 14, 11.
No, my lord, below 18. Below 18, above 16.
Can be there's a difference
No,
between
Lordship.
6,600 days. No, no.
6,000.
But where is the question of objection?
No, Lordship.
6,600 days. No, no.
6,000.
But where is the question of objection?
No, Lordship. She is legality.
Right. Third is
Devote Lordship.
he verbally and counsel for the applicant who submits that there is a delay of six, six,
6,600.
in filing the appeal against the impugned judgment by which the applicant has been convicted under section 302
Lordship.
IPC. The applicant's counsel submits that it was only after the applicant was able to make use of the services of the High Court, Guwahati High Court Legal Service Committee, that he was aware that he could file an appeal. Submit APP submit that he has got no objection to the delay being followed. In view of the above, in view of the reasons given by the applicant and the submission made by the learned APP, the delay is condoned. I register this to list the appeal in a week's time. I accordingly dispose.
Obliged.
In this item, my lord, I pray for some more time to take steps, my lord.
Yes.
No, we cannot take steps, my lord.
Okay, when will you file, when will you take steps?
Within a week, my lord.
Mr. H. Gupta, learned counsel for the applicant, Union of India, submits that prays for a week's time to take steps in terms of the order dated 6/8/25. This is the matter after the vacation.
Yeah, please, Your Lordship. Lordship, kindly grant 1 day time, Lordship. We will take the first step. A. Sharma on behalf of B. Chakrabarti.
A. Sharma, behalf of
B. Chakrabarti.
P. Chakrabarti CGC,
Yes, Lordship.
submits that she will take steps for service of notice upon the respondent within 1 day. Within
Yes, Lordship.
2 days, 1 day.
Today, Lordship.
Today you take.
No,
2
Lordship.
days. Wait 2 days. This is the matter after the vacation.
Lordship, kindly 1 day or 2 day time may be given.
For what?
For this hearing, Your Lordship, because what happened, Your Lordship, since 2 days, Your Lordship, I had been infected with viral infection, Your Lordship. So, honestly speaking, Your Lordship, I could not even run through single word. Otherwise, I have a
You see
case.
you see the only issue here.
Maintainability, Your Lordship.
You want the NPA status to be made into a standard asset, correct?
Lordship, Lordship, Lordship.
Now, and accordingly, you have made a challenge with regard to an order made under section 7.
No, Lordship. That order has never been challenged, Your Lordship.
No, but you can always go in appeal under section 18.
Yes, Lordship.
Then
Some few grounds are there, Your Lordship. Otherwise,
you
whoever
can
Your
fix
Lordship.
this aspect
Yes,
before
Lordship. So
the-
I can.
there's nothing here,
Lordship,
madam.
kindly give me one opportunity so that I can.
Tomorrow. No, for whether you are ill or you do not come, we are disposing it of tomorrow.
That will be day after tomorrow, Your Lordship.
But you have to be here.
Lordship, I will be there, Lordship. Ji, Bora, Lordship.
Miss, what is the name?
Ji, Bora, Lordship.
Ji Bora. Learned counsel for the petitioner seeks upgradation of his non-performing asset against the home loan to standard asset on the promise of making payment of all outstanding due. This petition has been put to challenge on the ground that there is an efficacious alternative remedy available under section 18. Of the Sarpaci Act 2002. In as much as the petitioner has already availed the remedy under section 17 of the Sarpaci Act, which was, however, decided against the petitioner, correct? Decided against. Considering the above, it prima facie appears that the present writ petition is not maintainable. Miss,
Lordship, I'm thus appearing on behalf of SK Methi, CGC, for respondent number 1.
Miss, you got a name? Miss Hemdas
M.
appears on behalf of Mr. S.K. Mehdi, CGC, counsel for the respondent. On the prayer for adjournment made by the petitioner, list this matter on day after tomorrow. No adjournment will be provided on the said date, and the matter will be decided even in the absence of the party.
Right, legal. But in this case, Mr. AML will argue, my lord, he is on leg in court number 16, my lord. After some time, my lord, if possible.
Juvenility, again, the
Yes.
Lordship, we have already finished our part.
You have also finished your part,
Finish only, it was for orders, no?
but I have not finished my part.
Lordship.
He's coming within 5 minutes, my lord.
But there is one aspect that needs to be considered. This question of plus minus 1 year.
Lordship.
I think when you look at the various judgments of plus minus 2 years or plus minus 1, this is when an exact age cannot be determined. And when an age range has been made by the board, medical board, say from 23 to 25 or 25 to 30.
Then
in some cases, there's 20 to 30 also.
Lordship.
Now, you cannot use that plus minus formula in these cases. I don't, that will be making a mockery. That will amount to, for 20 will become 18, because if you take the lower side. If you take higher side, it will become 22. But if you take lower side, because it has to go in favor of the scale. So it becomes 18. And supposing that 30, you take it to 32, then the difference will become 14 years. 14 from 10. But if you take it both, make it smaller, 122 and 130 to 20, then becomes 6 years. So I don't think that is the intent of the provisions of law or the decisions made by the Supreme Court with regard to giving of plus and minus. I think when a range is given, subject to correction, when a range is given by a medical board, I think we have to find out the mean age. Say, there is a, say, 23 and 25. Mean age will be 24. Now, once you come to the mean age, then maybe you can apply that plus minus, whether it be 2 or 1. So I think that mean age will be, otherwise, it's going to be a problem. Supposing the medical board says that person is from 22 to 30. Now, huge. And there is somewhere I saw the one judgment where the board had said 20 to 30 years. Now, unless you have a mean age, how are you going to apply that plus minus formula? I want you to give a slide, some submissions on that score, whether when there's a range in the age, whether a mean age should be taken from, so that we can apply that formula.
Lordship, and let it be on Monday, Lordship, then. Then Miss Bhuya will be also there, Lordship, because she have gone through this all records and all.
No, I want his counsel, his senior to be here, so that in the meantime, y'all can also look into, judgments of other high court.
Lordship will have to go through.
Yes, because
Exit
the prima facie view that we're getting is maybe mean age might be the best.
Nearly, if it is between 16 to 19, then also something can be done.
Yes,
But
some,
if it cross above 20,
Hmm.
then it become that.
No, what I'm saying is.
That we'll have to see what judgment is there.
Not 20, with the, talking with the ranges.
Exactly.
You see, the variation of an age, as per the judgments of the Supreme Court, can be plus minus 2 years.
2 years.
Correct?
Lordship.
So supposing the board says that person was 19 years.
Lordship.
So if he's 19 years, plus minus will be 17 or 21.
21.
Very easy.
Very easy.
Or if it is 1 year, it will be 18 years and 20 years.
20 years.
Now, if that is the range, supposing the board says he is
20 to
between
30.
19 and 20.
That is.
Now, how are you going to give the benefit of plus minus? Are you going to take it from 22 or you can take it from 19? As per the judgments of the Supreme Court, you have to take it from 19. But was that the intent? I don't think that was the intent when there's the range. I think for that, we'll have to get the mean age, and from the mean age, probably you'll have to think of giving plus or minus 1 or 2. So, on that 4, I want to do. So anyway, what do you say now? What do we do?
Lordship, let it be on Monday.
We are senior, where is he?
Court number 16, my lord. Order is delivery.
So Monday, Lordship. Coming Monday.
You understand what I'm saying, no? Did you understand?
Or
Or it went over your head?
I thought she is not so much aware. Lordship, as Miss Bhuya is out of station, Lordship.
No, you too, you can tell her what I want.
I can.
But he cannot, he is not in a position.
Lordship, I'll see, Lordship. Exactly, there are some citations.
You can tell his senior.
Lordship, I'll inform.
The anxiety of the court and what the court wants to know. Okay.
That I can tell.
You can tell his senior.
Right.
Because he is not in that position.
Lordship, I'll inform.
Some assistance in that regard.
Lordship,
That's what my lord.
Lordship.
You've got to do some, you've got to try, you see, one thing. When I had a junior, I had many juniors. One of them, I told them very clearly, please read a lot of magazines, a lot of newspapers, English, so that they get some idea of the English language. The more you read, the better you become. I'm not good, but it helped me a lot. It helped my junior also a lot. So try and read the English newspapers. So that you'll understand, because in High Court you're doing everything in English. Okay. Okay, right. On the prayer, the parties list the matter on Monday.
Lord, before delving into the matter, Lord, I'm extremely sorry, my lord. The last occasion, my lord.
No problem.
It's regarding this review petition, my lord.
Okay.
My lord, on that day, my lord, I was extremely, my lord, concentrated, focused on this Article 311(2) second provision and other aspects, my lord, regarding back wages and other things, rules of Guwahati University. My lord, left untouched. So, my lord, this review petition is only for issuing notice to the appeal proceedings, my lord. Since it's an institutional appeal, some cascading effect will be there, my lord, since it will open a floodgate. And for us, my lord, this division bench is the Supreme Court, like Supreme Court, my lord.
Maybe, but then we are bound by the law.
Crucial aspects are there, my lord. And so, my lord, the prejudicial aspect of the SK Sharma's judgment and the rules, all these aspects have been left untouched. Only it is my fault, my lord, that on that day I was totally focused on that.
Oh no,
311
you can always make a correction now. Tell us what.
That is why, my lord, my only
do you want?
Only prayer is that there is only one respondent, my lord, and this back wages amounting to rupees 50-60 lakhs, and there are similarly situated other persons. Some cases are pending. So, my lord, since those aspects should be heard, my lord, in depth. So notice may be issued on that retaping, my lord. And to that extent, my lord, I have filed this review. On the very first day, my lord, it was closed, my lord.
Naturally.
It's my fault that I could not, my lord, bring up those aspects, my lord. Some crucial aspects, my lord. 3 show cause notices. If show cause notices are issued, then as per SK Sharma, entire matter will have to be, my lord, checked, examined on the touchstone of prejudice. Those aspects are there, my lord. And regarding back wages, if he is employed gainfully in another employment, those aspects will be considered. Now, learned single judge, my lord, relies on that Subharam case. But after that, my lord, it is 2016 case. But in 2023, there is another case of Sirajuddin that was distinguished. If it is willful absent, then back wages won't be given. But if it is not willful, if he is not gainfully employed, then those back wages won't be given. So those crucial aspects, my lord. So it may be hard, all aspects, my lord, in details, my lord. So notice may be issued, my lord. That modification, my lord.
How can you do that now?
Since, my lord, it's a review, and under CPC Order 47, Rule 1, as per as those, my lord, Lily Thomas case, my lord. My lord, since, my lord, this honorable court has the discretion to review the matter, review the earlier judgment order. On the very first day, it was closed, my lord, only on that aspect particularly.
Because you pressed only that aspect.
My lord, other aspects, I thought, my lord, that was my fault, my lord. I thought that notice would be issued, and only that aspect has been brought up, my lord. Other aspects, my lord, other grounds could not be placed, my lord. So, my lord, my only prayer is that notice may be issued on that retapability, lord.
No, how do we do that?
My lord,
when we have decided a writ appeal on a particular point.
On that point only,
And
but other grounds are there. Other grounds are there. That is when.
But when that.
On the very first day, my lord, that was closed, my lord, and I admit, my lord, that was my fault. That was entire matter, my lord. On that day, my lord, I was focused only on that second proviso of 311(2), but not on prejudice aspect and other aspects, my lord, including back wages of, my lord, large amount, my lord. Even the private respondent, my lord, the sole private respondent, he approached the Guwahati University Authority with a representation only to modify the termination order to compulsory retirement, so that he could get retirement benefit. He's not against that termination order. Those aspects are there, crucial aspects. I'll place those aspects one by one. So, my lord, a lengthy hearing would be required.
No.
In the context of the Supreme Court.
You want a lengthy hearing, we don't want.
My lord, since, my lord, that back wages aspect, and some paragraph, my lord, paragraph number 30, my lord, for instance, show cause notice was not issued as per honorable single judge's, my lord, observation. But 3 show cause notices are there, including 1 paper advertisement. Still, he chooses to be absent, my lord.
But those have been considered, but
Not considered. Not considered in the writ appeal proceeding, my lord. On the very first.
You look at the single judge's order, it
My
is
lord,
here,
my lord,
37 page 83.
my lord.
It is here that
Para 30, my lord.
from 36, you see, in view of the above position, the authorities of the Guwahati University are directed to compute the salaries receivable by the petitioner with effect from 24/9/2020.
That Subharam was distinguished later, my lord, by Sirajuddin. I'll place those judgments. my
You
lord.
go to the Supreme Court, I think. I don't think there's any case.
My lord, at
We
least,
cannot
my lord,
reopen close thing which is not challenging on. They are only challenging on the ground of salary,
my lord,
not on the merits of the case.
my lord, on that day, my lord, only that, my lord, dispense with the inquiry under Article 311(2). And that was taken up, and that was my fault, my lord. And other regarding that back wages.
No
aspect,
case, Mr. Khan. No.
So, my lord,
We
at least, my lord,
No. Where you.
my lord, at least notice me.
You see,
Everything
everything can be done by the Supreme Court. You go to the Supreme Court.
No, my lord, it's an institutional.
No,
act,
no,
my lord.
no,
And
no.
pardon, my lord, on the very first
No,
day,
no,
my lord,
Right.
my lord, that was my fault as an advocate, my lord, as a counsel. The only one aspect, my lord, I have focused, my lord. And on that day, my lord, my lord, pointed out that there are some other grounds. And
that is the main ground.
I did not think, my lord, that at that time that it will be closed on that day itself, my lord.
That was
my.
That was the only ground press. How are we to?
these are salaries consequence.
So, my lord, I take your lordship before, my lord, delving into the matter. The grounds, my lord.
No.
The grounds of
There
the
is
appeal.
no case, Mr. Khan.
The grounds of the appeal, my lord.
Heard Mr. P.J. Fugate.
There are several grounds, my lord.
Review petition.
My lord, at least, my lord, my submission regarding back wages, my lord,
No,
that may be considered.
we will reflect that.
On that day, I could not submit, my lord. So, my lord, for any default or
No, you see,
the council concerned, my lord, the institution should not suffer, my lord. Particularly legal aspects, my lord. Otherwise, it will be a legal chaos, my lord. Those grounds, my lord, it is clear from the grounds, my lord. The grounds enumerated in the.
Where is your affidavit that it is due to your mistake? Where is your affidavit that it is due to your mistake that you could not make submissions on other grounds?
My lord,
where is their admission by you in the affidavit?
I will be allowed to, my lord, file additional affidavit. At least that opportunity, my lord.
We cannot allow you to better your case as the time goes on.
No, my lord, it's not bettering.
That is what you are saying. You are making submissions here that it was due to your mistake that you could not make submissions with regard to the salary of the workman.
My lord, obviously, my lord.
No. Then when you make submissions like that, that has to be in your.
Then, my lord, I am withdrawing that submission of mine, my lord. Then kindly turn to those grounds of the appeal, my lord.
No.
That will clarify the position.
You see this appeal petition.
Now, in the grounds of the appeal, my lord. Kindly, my lord.
This is not an appeal in disguise. This is a review. A review you have got to show us if there is any apparent.
So, my lord, that Lily Thomas, I will be allowed to place Lily Thomas judgment. Those judgments, my lord.
How will Lily Thomas help me?
My lord, Lily Thomas judgment is in favor of me, my lord.
What does it say?
My lord, that review, my lord, may I place, my lord?
Wasting of time.
No, my lord, since, my lord.
Sorry, Mr. Counsel. Unfortunately.
Lily Thomas. Para 52, my lord. I have marked some sentences, my lord.
Right.
52, my lord. May I read, my lord? I have marked, my lord, only 2-3 sentences, my lord. Page 249. In exercise of this power, Order 40 had been framed empowering this court to review an order in civil proceedings on grounds analogous to Order 47, Rule 1 of the Civil Procedure Code. the expression for any other sufficient reason in the clause has been given an expanded meaning, and a decree or order passed under misapprehension of true state of circumstances has been held to be sufficient ground to exercise the power. Now, down below me. Apart from so and so, Supreme Court rules, this court has the inherent power to make such orders as may be necessary in the interest of justice or to prevent the abuse of process of court. The court is thus not precluded from recalling or reviewing its own order if it is satisfied that it is necessary to do so for sake of justice. Now, my lord, down below, my lord, paragraph 53. My lord, relying another case, my lord, of Northern India Caterers Limited versus Lieutenant Governor of Delhi, my lord, para 8, my lord, that is quoted, my lord. It is well settled that a party is not entitled to seek a review of a judgment delivered by this court merely for the purpose of a rehearing and a fresh decision of the case. The normal principle is that a judgment pronounced by the court is final, and departure from that principle is justified only when circumstances of a substantial and compelling character make it necessary to do so.
Okay, right. Third, Mr. P.J. Fukan, learned counsel for the appellant, who submits that the impugned order dated 13/8/2025, passed in WA 255 of 2025, should be reviewed in as much as he was not able to project the other issues in the writ appeal while at the time of disposal of the writ appeal. He submits that the review petitioner had not made submissions with regard to the payment of salary of the respondent, which the appellant, which the respondent was not entitled in terms of various decisions of the Supreme Court. System. He also submits that in terms of the judgment of the Supreme Court in Lily Thomas versus Union of India, reported in 2006 SCC 224, this court has the power to review an order for any other sufficient reason as provided in Order 47, Rule 1, CPC. First up, we have considered the submission of the learned counsel for the review petition. The petitioner's termination from service had been done under Clause B of the second proviso to Article 311(2) of the Constitution, without there being any satisfaction being drawn by the authorities, to the effect that it was not reasonably practicable to hold a departmental inquiry against the petitioner, review petition, in terms of Article 311(2) of the Constitution. The learned single judge, while the judgment and order dated 6/9/2024. Passed in WPC 6962/2021. Had set aside the termination order by following the judgment of the Supreme Court in the case of Union of India and another versus Tulsi Ram Patel and others reported in 1985 3 SCC 398. The appeal filed by the review petitioner, that is WA 255/2025, was dismissed by this court on the ground that the review petitioner had not been able to show, review petitioners had not been able to show that they had made any recording of their satisfaction, that it was reasonably practicable to hold an inquiry under Article 311/2 of the Constitution, prior to invoking the said clause for terminating the service of the petition. The next para. The review petition in the present review petition has not made any submission, has not shown this court any document showing that the review petitioners had recorded their satisfaction that it was reasonably practicable, that it was not reasonably practicable to hold an inquiry under Article 311(2) of the Constitution prior to invoking the said clause for terminating the service of this court. As such, we do not find any ground to allow this review petition. The same is accordingly dismissed.
My submission will be recorded regarding back wages. Since Milord that Subharam has been distinguished later in Sirajuddin Khan case, and that SK Sharma's
that he's not eligible for back wages.
No work, no pay. Milord.
Okay.
That is-
The review petitioner's counsel submits that the respondent is not
Milord, again, Milord,
liable to
since-
receive any salary during the period he did not do any work with the writ petitioner, with the review petition. In terms of the judgment of the Supreme Court in the case of
Sirajuddin Khan. Milord.
Sirajuddin Khan versus
Milord, SIG Regional Manager, United India Insurance Company Limited versus Sirajuddin Khan. 2019.
That's all. Okay, the one thing you write in the paragraph is it. The question of the being eligible for not being eligible for payment of salary for the period he had not worked was not an issue that had been decided. It was not an issue that had been raised at the time of hearing the writ appeal. And as such, no decision on that score had been made by us. the issue at the time of disposal of the writ appeal was only with regard to whether Article 311 bracket B could have been
There is.
could have been could have been applied for terminating the service of the as the issue as the issue of salary was not an issue during the appeal. At the time of disposal of the appeal, we are also not taking up the said issue at this stage.
Milord, there is another aspect, Milord. Milord, that
No more, enough.
appellate provision, Milord, your lordships, that order reflected, Milord, regarding that appellate provision, Milord. So, Milord, regarding appellate provision, Milord, of the writ petitioner before departmental appeal, Milord. So, Milord.
You go to the Supreme Court.
Milord, on those two grounds, Milord, one, 311(2), second, departmental appeal.
You go to the Supreme Court.
Milord, my submission, Milord, regarding that departmental appeal, Milord, at least, Milord.
Sorry, we cannot, we do not agree to we cannot record everything that you want.
Entire writ.
You can always go to the Supreme Court.
Milord.
If you're not happy with our order, you can always do that.
Milord, that is another aspect, Milord. Since, Milord, there are two grounds, Milord, that writ appeal has been dismissed by this honorable.
We will award cost against your client. You say one more word, we're going to award 10,000 costs. And every time you say others, we'll make sure that the review petitioner pays someone. We have heard you. Enough.
Then, Milord, I will have to stop, Milord.
Yes.
Milord, most of that.
Yes. Lordship, can the matter be held at Thursday, Lordship? Otherwise, Lordship, I have plans from Lordship. There are two eyewitnesses there, medical is there.
There's section 6.
No, Lordship. 302.
Lordship, I may be allowed to submit my written submission if my landed friend is sick.
What do you mean written submission, Mr. Ram? No. What do you mean written submission? Before you even start your oral submission, you want written submission.
I'll start.
What is this? Then you just give us and you go home. Why do you want to even make a thing?
We have some dates, Lordship, for which I referred to. Because GD&T was there, that also some chronological dates I have given, which is not available in the record, for which, with all respect, Lordship. Otherwise, I'll remember. But after my submission, if I may be allowed to submit the same for the showing the list of dates, how the FIR was, and that to Lordship for assistant Lordship for appraisal of this matter, Lordship, to the Honorable Court, for which I pray for producing this thing. Otherwise, Lordship, the date of occurrence, every list of dates I have mentioned in my submission.
There's eyewitness or not?
No, Lordship, that also I have some, with all respect, some objection on that. Because GD&T was made at Silchar. There, that two eyewitness was the 161 statement is there. And they were not the eyewitness, with all fairness, absolutely. For which I have given all the details.
They were not the eyewitness.
They are not the eyewitness. They are not the, with all fairness, I am submitting. I have given the statement, Lordship.
I've never heard of a lawyer who will say that I am submitting unfairly.
Lordship.
Everyone submits fairly.
Lordship, that time, without actually some difficulties, both from the prosecution side and the defense side, for which the petitioner before your Lordship is the victim of 302, Lordship. Maybe it may be 304 part 2. But co-accused also released, Lordship, acquitted.
So if you're saying that.
No, Lordship, that I am not claiming. If your Lordship finds the involvement of the accused is directly on that additional prayer I am making, that only that.
No, because once you start invoking 304 part 2,
Lordship,
Then
Because
it-
already he has completed 28 months. 11, that is 2.5 years more lordship in jail. And he is 73 years of age. My respect to submission on that kindly consider. Because he will die, lordship, he is terminally ill as per report of the jail authority to the legal service authority.
We're not on that. You see, I can understand on bail, but not on the question of whether a person is guilty or not. We cannot go into the.
Lordship, that too, whether that part, lordship, the learned session judge has not considered that GD entry as well as the other witnesses, those who are in the inquest as well as postmortem doctor was examined.
What happened? So the investigation was started on the basis of the GD entry.
No, lordship, subsequent FIR after 3.
So how does it matter?
Lordship,
The FIR
after 3 days, lordship. After that, and there are some judgment.
So the
First GD entry should be treated as a first FIR, lordship. Because
only investigation is started on the basis of the GD entry.
lordship, because this man was shifted from.
How does it matter? So what is the prejudice caused
Lordship.
by the filing of the subsequent FIR?
FIR lordship, prejudice lordship, because they are saying the PW1 and 2, they are saying the eyewitness. But before the police of Silchar Gungur Medical College, they were only an inquest witness. I have given the translated, I have made it all translated, lordship. If your lordship finds anything on that, my respect to submission, lordship, since 1 and 2, they are not the eyewitness. Only the victim has informed after 3 days. What has happened? I'm just stating the facts of this case. It was happened, lordship.
When the victim informed, victim will be dead.
Lordship, victim died, lordship.
Then how can victim will inform? You said victim will inform. How will victim inform? A dead
No,
person
no.
cannot speak.
No, victim, lordship, after 3 days, lordship. From Hailakandi, he was shifted to Lala Hospital, then Hailakandi Hospital, then Silchar Medical College.
Then
Their lordship GD entry was made at Gungur. And then 161 statement was recorded of PW1 and 2. That was not taken into account in the judgment as well as entire lordship, entire trial lordship. It was a complete lordship, the inquest witness as well as the inquest who has made the IO, that IO who has registered the GD entry, he was also not examined, which is a serious lapse on the part of the prosecution. So
I think I forgot. My brother has got a single bench bail matter. 25. So everyone will be waiting for him.
lordship, I leave it to your lordship. I pray, lordship, if I may be allowed to, for convenience of this honorable court, to know about the basic origin of this case, for which I.
No, we'll hear you. We are ready, but I just remember.
Lordship, please just any day subject to convenience, because I also make some notes of some judgment of that. This week, if possible, lordship.
This week I'm having DB1 matters also. Slightly very DB1 matters.
Lordship, please.
Slightly
16
a little bit of reading is required in DB1 matter.
This is not possible, lordship. The next week.
Next week?
Next, 16, there are 2-3 matter already fixed.
Where do you?
Can it be as part of lordship, please?
No. There's nothing started about it. Nothing has started. This is a matter on 17.
Any hearing day, lordship, motion day, it may.
17.
Lordship. So. Lordship, then whether I should just supply the copy of my written submission, if please, lordship, on that day, lordship. Then.
Only after hearing you.
Lordship, please.